For those on Teams, we're just going to be starting in the next couple of minutes. Thank you.
Good evening. Welcome to this evening's meeting of the Planning Committee of Woking Borough Council on 11th of January. Sorry. This meeting is being held as a hybrid meeting with the committee members present in the room this evening, while some of the officers are attending in the meeting in person and some are connecting via Microsoft Teams. The meeting is being live streamed on YouTube. My name is Councilor Rochelle Shepherd-Debay and I chair the meeting. The Planning Committee consists of 9 elected member borough councilors who are supported by a variety of professional officers. This is a quasi-judicial committee with formal set procedures which are adhered to. Firstly, the planning officer will present the application, and then only those speakers who have registered to speak will be invited to address the committee. No one else, including borough councilors, town and parish councilors, agents, applicants, objectors, and supporters, are permitted to address the committee, ask questions, or disrupt the meeting. Everyone has had the opportunity to comment on this application through the consultation process. Please note there is a strict limit of 3 minutes per category speaker, those being town and parish councils, objectors, supporters, and those borough members affected by the application. Members of the committee are more impressed by the quality of what you have to say rather than how long you speak, but above all, please stay within your time limit. Following the registered speakers, members of the committee will discuss and debate each application and seek clarification from the council's professional officers in order to try and reach a decision. The decision reached by the committee may or may not agree with what was recommended by the presenting case officer. Finally, it is the committee's responsibility to determine any valid planning application presented for it by using current national and local planning policies and relevant decisions of the relevant planning inspectorate. Our role is not to suggest alternatives to applications, nor to consider whether they're a good idea, whether they're needed, whether they're too costly, or whether they're alternative uses of the site or more suitable uses of the land elsewhere. If you are joining us remotely, please ensure your camera is switched on only when you're speaking and your microphone is unmuted only when you're speaking. Any apologies?
Thank you, Chair. Apologies submitted from councillors Chris Bowring and Stephen Conway.
Any declarations? Minutes of the previous meeting? Are members happy with the minutes of the previous meeting? Okay. Show of hands. Thank you. Declarations of interest? Alan, David?
Right, okay. 222963. Right, this application and its predecessors falls within my early town council ward. And going back to before I was elected to this council and appointed this committee, I've been helping residents with a number of applications at this site. Therefore, I declare a prejudicial interest in this agenda item and will withdraw from the room when it is discussed. Right, 222170, 17 Byron Road. Preceding my time on this council and committee, going back all the way back to 2019, I've been on the early town council planning committee where these numerous applications have been considered. I have never had direct contact with the residents about this and was not at last night's ETC planning meeting. So I think that I can attend for that this discussion. 223493 Tanhouse Bridge. I see that the group Watch, the Woking Active Travel Community Hub, are here tonight to object. This is not a formal membership group, but I do receive their communications. With respect to this application, I've only advised about the procedures of this committee, so I think I can sit to that item.
David?
As ward member for Finchampstead South, I've requested the application 223021, item 73 on the agenda, to be listed, both at the request of local residents and Finchampstead Parish Council, but also because there are some aspects which I felt appropriate to be considered by the planning committee. However, I am attending the meeting with an open mind and will listen to the debate before making any determination on this application.
Any other declarations of interest? We will have a 10-minute break at 9 o'clock for equality, diversity, and inclusion. Thank you. Start off with application 22138, 6 Johnson Drive. Have any applications been withdrawn or deferred?
No, thank you, Chair.
Okay, we're going back to 6 Johnson Drive right now. And the officer is Cameron.
Thank you, Chair, for the introduction. This is a household application for a proposed single-storey detached outbuilding with roof lantern to the eastern boundary, and it's also retrospective. An additional condition to secure obscure glazing for the shower room and WC windows to the east elevation of the outbuilding has been outlined within the supplementary agenda. The application site hosts a 2-storey dwelling located in Finchampstead within the countryside. Proposal seeks a retrospective approval for a single-storey detached outbuilding with a roof lantern to the eastern boundaries. The trees on the eastern boundary of the site are protected by an area TPO. The outbuilding has already been partly constructed with its external walls, roof timber and window openings in place as shown in Figure 1. The outbuilding has also been constructed in the place of a previous patio and concrete slab. The pre-existing patio and concrete slab was originally 200 millimeters thick and was increased in depth to support the new structure by adding new material on top of the existing slab, thereby not having any additional impact on the roots of the protected trees adjoining the site. The slab has been in place for many years as circled in red. The proposal sought for an outbuilding that would be a single story with a 30-degree pitched roof finished with slates. The proposed outbuilding would be a private garden/study room, shower and WC incidental to the host dwelling. Proposed outbuilding would be solely used for purposes incidental to the main dwelling house. No change of use proposed. And here are some photos of the said proposed outbuilding as well as the main dwelling. The existing dwelling is 2-storey and clearly retains its position as the dominant structure on the residential plot. Hence, the proposal is suitably proportionate addition to this residential property given its subservient appearance in nature. It does not lead to an excessive form of encroachment or expansion of development away from the original buildings. The proposal sits within the established property boundary and is located to the rear of the existing dwelling and wouldn't be visible from a public realm. It is therefore considered that would not lead to excessive encroachment into the countryside, nor have an adverse impact on the character or of the host property or surrounding area as shown on the previous slide. The proposal does not give rise to unacceptable level of overlooking, overbearing or overshadowing. The proposal is approximately 71.9 metres from the property at the rear, 293 Narmar Ride, and the side of the proposal is approximately over 60 metres from the rear of 287A and 287B Narmar Ride, therefore complying with the separation distances set out in the Council's Borough Design Guide. Furthermore, the outbuilding would be naturally screened and its visual appearance softened by the mature and established vegetation and trees, which are taller than the height of the outbuilding, therefore posing no threat with regards to its neighbouring amenities, as shown on the previous slide. Therefore, in conclusion, proposal is considered not to harm the character of the area nor neighbouring amenities. Proposal also complies with CP1, CP3, CP11 and the Borough Design Guide, subject to conditions. Therefore, the application is recommended for approval. Any questions?
Okay, the first speaker is Charles Margetts on this application.
Thank you, Chair. I know that members are meant to judge applications on an individual basis. However, to understand this application and the full picture, it's important to understand the history of the site. 10 certificates for change of use on this site since 1997, 8 refusals by WBC, 7 applications for this one for housing, including many appeals, 20 enforcement matters on this site since 1998. This, however, does not tell the full story of what this applicant has inflicted on his neighbours for 25 years. Dumping of commercial waste, dumping and burning of green waste, endless bonfires, and of late, the storage of 200 plus scrap cars on the site. Residents have shown me videos showing people accessing the site and stripping parts from scrap cars. One resident, whilst tending his garden one morning, was approached by a man asking which house on Johnson Drive was the property where one could buy scrap cars from. Now, why is this relevant? Because it gives you a bit of the background and understands the strength of feeling. This site in particular is in the countryside. It's outside the settlement boundary in the 2010 local plan. It's in the countryside and outside the settlement boundary in the 2022 draft local plan. It's not included in the Finch-Hampstead Neighbourhood Development Plan, which has now passed the Reg 16 public consultation and should carry existing weight. What is the point of making plans if we don't follow them? So why does it matter? For something of this size, the applicant has shown through his past behaviour, which is fully shown in the agenda pack, a continual disregard from the local plan and the enforcement process of this council. He's no respect for our plans or policies. The approval of a building such as this would seem like a small thing, but residents are heavily opposed because trust has completely broken down because of the past behaviour. Experience shows, and you can see this in your agenda packs, that with this applicant, if you approve this application committee, the next time one of our enforcement officers visits this site, there'll be 2 new buildings in the countryside without planning permission, or more builders' storage or scrap cars. Where does this end? When will the council take a stand? As members, we need to send this applicant a message that our development plan is there for a reason. We need to show our residents we'll defend our plans. We're not going to roll over in the face of people who ignore them, and we'll protect the interests of residents against this creeping, pervasive development in the countryside. I'd therefore ask the Planning Committee to reject this application.
Councillor Roger Marshall-Say of Finch-Hampstead Parish Council.
Thank you, Chair. Can I just have a point of clarification to begin with? Are we talking about the first item on the agenda or the second?
Apologies, I believe you're registered for the second application.
Yes.
That is correct,
The
Chair.
houses, yeah, sorry, apologies.
Other members? Anybody want to? Would anybody like to speak on this?
Thank you, Chair. I would like to address some of the issues that Councillor Margetts has raised this evening, just to ensure, that we all have a similar understanding, of the matter before us this evening. Planning and enforcement history is not a material planning consideration. It's not something that we are able to consider when debating the application before us tonight. I can appreciate from the vigour with which you presented tonight that there does appear to be considerable strength of feeling of some members of the public about this application. And I can empathise with that. You did specifically raise the matter of the Finch-Hampstead Neighbourhood Plan, which I believe is at a stage of development currently where it does not carry significant weight in the present circumstances. That is my understanding, and I would like to ask the officers whether my understanding on that issue is correct in a moment. I do, however, have one suggestion. for an additional condition. A roof light is shown in drawings on page 37, and reference is made to bats in the area. There is a condition proposed requiring approval of an external lighting scheme. I'm wondering whether other members would be minded to amend that condition to include roof light blinds to help mitigate any potential upward light spillage at night that might affect the behaviour of the bats and the foraging of the bats. So I've asked one question of the officers and made one proposal that I would like members to consider with a small amendment to the condition.
David, second, and John.
Thank you, Chair.
Was that about the same? Are you seconding the?
No, I'm not.
Okay, then it's John, unfortunately. He asked first.
Thank you, Chair. Can I just ask the officer, was this application submitted voluntarily or was it subject to a negotiation between our enforcement officers and the applicant?
I believe it was enforcement. Yeah.
So this has been discussed with the applicant, and the council have spoken to the applicant and said, well, if you submit a planning application, that planning application, we will recommend that application.
Yeah, the application will be determined if it's acceptable or refusal or not.
Right, the second question I've got on that, sorry, just one other quick. You've obviously feel it should be recommended. What do you think an inspector's view would be on this? Bearing in mind that we've already been in negotiation with this person to remove an enforcement case.
For me personally, from what I've presented, I believe it should be approved. I've given the reasons in my pack, as well as what I presented as deeming, so I personally believe it should be approved. It doesn't have an adverse impact upon the character of the area or neighbouring amenities, nor impact on the countryside.
Okay, thank you. But again, I just go back to that we've been negotiating with the applicant to stay the enforcement.
Thank you, Councillor Kaiser. If I jump in on that point, the application, the NPPF, so the NPPF states that enforcement action from a local planning authority is discretionary, and that councils should act proportionately in responding to suspected breaches of planning control. In doing so, if a breach of planning control is identified and there is a reasonable chance of the application being approved, an application should be entertained. An element of expediency is exercised in determining the application. If the council was to refuse the application and it go to appeal, there would, on the contrary, there would be the chance that the application would be allowed at appeal. So again, the control lies with us as a local authority to regularise what is unauthorised development at the moment.
I understand that. It's not criticism, it's a question basically. You are supposed to negotiate where you can, and if you go to appeal and you have negotiated and then it's been refused, it's a very difficult situation, puts the council in.
Yes, I think the key element of this is it's discretionary, and we should act proportionately. And if something is unlawful but would be granted planning permission, every opportunity should be used to regularise that, rather than refusing with the risk of it being allowed at appeal and drawing out what is otherwise a process that can be shortened.
So what you're really looking at is where the greatest harm is, whether to approve
Absolutely.
the application or enforce, and you believe that
Absolutely.
the greatest harm is not to enforce.
We would only enforce if the application was refused.
Okay, that's all right. That explains to me. Thank you.
David?
Thank you, Chair. Far be it for me to correct Councillor Mickleborough, but if you look at the supplementary agenda, you'll note that the Finch Hampstead Neighbourhood Plan now carries moderate weight, and that's the word of the council officers. I personally think that's an understatement, but I'll live with it. If I refer back to Councillor Marget's comments, I have to say I agree 100% with the sentiment he's expressed. But unfortunately, there's 2 points on which I would disagree. The first is I note that Finchampstead Parish Council hasn't objected to this application. And if we put aside the sorry history of this particular site, it is a fact that both the Parish Council and indeed the Borough Council have approved various small building additions standing alone in the curtilages of large properties all across Finchampstead. And reluctantly, I do feel on this particular point we may need to be consistent.
Yes, thank you. I looked at this and I thought that I would consider this permitted development. Is there going to be a condition that it is a separate building? I have every sympathy for what Councillor Margetts have said. You know, I've been aware of this site for many years in a previous role in the council, and I think it was on the sheet every week when I had my meeting with officers. So I have sympathy, but as Councillor Cornish has just said, I genuinely think looking at this would fall under permitted development. I would like to understand if we could put a condition on to say this is not a separate dwelling, it's ancillary to the main use of the main property.
We have proposals for two different conditions right now. First one was presented by Andrew.
Okay, so that was an amendment to, suggested amendment requiring roof-light blinds to be added to the condition regarding external lighting. And the second condition was from Councillor Smith, okay, that this be regarded as ancillary to the main building.
And we're looking for a seconder now.
Thank you, Councillor. Yes, so there's two condition suggestions there. Officers can confirm that a condition to restrict the use of the outbuilding to ancillary purposes to main dwelling is acceptable, reasonable, and meets the tests. However, a condition relating to blinds, I might explore that a little bit further with you, with regard to internal drapery, whatever you want to call it, curtains, blinds, anything that may go up inside a dwelling or whatever happens inside the dwelling doesn't constitute development itself and doesn't make the scheme acceptable as it stands as presented to you in the agenda. So a condition would not meet the tests. Again, lots of things can affect what goes on inside a dwelling, as you know, and blinds, curtains, other kind of ways to restrict light escaping a building is not something we can control.
Could we make that an informative then instead? Would that be possible?
By all means, an informative can be put on, but it will hold no weight, and it possibly sets an unhealthy precedent with regard to what goes on inside dwellings.
Al?
Could we have a condition then that there should be no roof light in the building?
Again, that would fail the same tests. What goes on inside the dwelling is the building is, for intents and purposes, what you see on the externals, its impact. What goes on inside, whether someone has strong lighting, no lighting, natural lighting, or otherwise, is not something we can control.
But you can control whether there's a roof light in the roof, can't you? Whether there's a velux or whatever you call it. That comes under planning, doesn't it?
Yes, in terms of veluxes, but what we've got is the plans put in front of us. So what you're asking for, and just to clarify this, is a restriction on no velux roof lights. Is that what we're saying? Just to confirm?
I wouldn't support that.
Okay. The plans themselves are as you see in the agenda. The council will be conditioning those plans. There is no need to condition out any hypothetical additional development that's not included in the plans. If there is any deviation from the approved plans in future, then again, the development will have not been built in accordance with those approved plans.
We're now going to vote on Wayne's condition. Do we have a seconder? David? All those in favor? Anyone against or unanimous, but which it has. Now we're going to vote on the officer recommendation of approval for this application, unless there's a alternative proposal. Just a second.
Point of clarification, please, Chair. Are we therefore about to vote on the amended plans?
Yes. We need to vote on your condition.
No, we're not voting on the amended plans. We're voting on the plans as they are in the pack, but with the condition that
Yes.
we've just voted on.
Yes.
Correct.
It's with the additional condition in the supplementary planning agenda and Wayne's condition. That's what we're voting on. What's in favor?
Can I just say, I think it's important for the people here to understand that I don't like retrospective, especially when officers are put in a position that they have to negotiate a deal. The rules are wrong. It's not their fault. The planning rules are wrong. The enforcement rules are wrong. But I don't see anywhere else to go, I'm afraid. Thank you.
Do we have a proposal? We have a proposal from Andrew to go for the amended, but with all the two conditions that we've added. All those in favor, please. We're now going to the second application of the rear of Johnson Drive. Application number 223592. The officer Simon, would you like to go ahead?
Thank you, Chair. Application 223592 relates to land to the rear of 6 Johnson Drive, so it's distinct from the application that was just preceded this application. You'll see that application to the south of the red line there. This application relates to land outside the settlement boundary within the countryside. It's 1.4 hectares of land. There is an extensive planning and enforcement history for the site going back 20, 30 years. Most recently, there was an application in 2019 for 25 houses, dismissed at appeal, and an enforcement appeal from 2022 that was part upheld, part dismissed. That application related to building storage and car storage. You'll note the car storage on the site at the moment in the photo on the site at the moment. There is a High Court challenge being heard in March in relation to the inspector's decision there. So the application relates to the removal of all the uses on the land and the buildings on the right hand side, sorry, and replacement with 5 5-bedroom dwellings on relatively large plots. As I've noted, it falls within the countryside, so it's a departure from CP11. There's also, as stemming from the 2019 appeal, an issue with site sustainability. There were 15 parish council objections. Sorry, there was a parish council objection, ward member objection, and 13 resident objections. Primarily, those issues related to traffic, parking, construction issues, access, landscape management, ecology, and a lack of consultation. There were no consultee objections related other than sustainability on the site. On the screen at the moment, you'll see photos of the site as it currently stands. The vehicles have been removed from the land. Towards the northern end of the site, you'll see some external storage. These are the existing warehouse buildings on the eastern boundary. and that's the current status of the land towards the centre of the site looking north. This is the western boundary of a photo taken in 2020 with vehicle storage that has since been removed. The easiest approach to deal with this application is to revert back to the 2019 appeal decision and illustrate the changes that have occurred. So in 2019, there was a 5-year housing land supply. At the present moment, there isn't. So that requires the council to adopt a tilted balance in the assessment of the application. So where the issues of countryside development and sustainability, site sustainability were weighed in favour of the application previously, weighed against the application, apologies, the weigh in favour of the application, the benefits outweigh the harm posed by those impacts. The members' update does make some minor changes to conditions, partly in relation to 5 additional submissions that were received, and does address archaeology submission that was received after the consultation end date. Thank you, Chair.
Okay, the first speaker is Councillor Roger Marshall say this time.
Thank you, Chair. I'm speaking on behalf of Finchampstead Parish Council, who object to this application. To start, I'd like to thoroughly agree with the comments that Councillor Margetts made just now with regard to the state of the site over the years. It's been a bone of contention for the residents of Finchampstead, and in particular the local residents, for a very long time. My main points that I want to concentrate on are the fact that this development is not in accordance with the Finchampstead Neighbourhood Development Plan, and the site is not sustainable. Fortunately, yesterday I received a public domain pack which changed slightly as far as this application is concerned. The weight to which the Finchampstead Neighbourhood Development Plan may be judged. Correct. And it's gone from negligible to moderate. And that's certainly how one should view the points where it actually it is diametrically opposed to the policies in the FNDP. The main point is that it's outside development limits. And policies ADH1 in the NDP specify criteria where the development is allowed outside the development limits. None of those criteria are met in this application. So the application is actually contrary to the emerging neighbourhood development plan. In the appeal on the previous application, where there were requests for 25 houses, one of the reasons for objection by the inspector was that of sustainability. And he actually wrote in his submission, in his report, overall, I'm not convinced that the characteristics of the proposal's location would encourage the use of sustainable transport modes or provide realistic choice to support the opportunities for reducing the need for travel by car. As such, it would conflict with the thrust of core strategy, that's Woking Borough's core strategy, policies CP1 and CP6. So on these 2 grounds, not in accordance with the neighbourhood development plan and a non-sustainable location, I wish to oppose this application.
Good evening, Chairman and members of the Planning Committee. Thank you very much for giving me the opportunity to speak. My name is Patrick Bancroft, Chartered Surveyor and Managing Director of Bancroft Developments, who lodged this application. We have been building houses locally for over 30 years. We have worked closely with your planning officer on this application to make sure that the application is policy compliant. As you will see from your officer's comprehensive report, all planning matters have been dealt with to his satisfaction. In particular, I would draw your attention to the following points. One, there is a 10-metre landscape and wildlife buffer around the perimeter of the site, ensuring that all trees and wildlife are fully protected. Two, the application meets all parking standards and has the appropriate turning facility for refuse and emergency vehicles. The fact that there are just 5 houses will actually reduce vehicle movements in and out of the site considerably. In particular, large commercial vehicle movements will be reduced to virtually none. 3, the 5 proposed houses are generously spaced apart and well away from the neighbouring properties in Tomlinson Drive, making sure that there are no overlooking issues. 4, as the committee will be aware, the site already has existing brownfield uses, established and confirmed at recent appeals, where the inspector concluded that such uses are lawful. These uses will be removed for good if this application is approved and the houses are built. 5, the effect of the proposed development on the character of the local area is minimal, with only glimpses of the development visible from outside the site. In fact, with the extinction of the brownfield uses, the appearance of the site will be improved. And 6, it is a fact, as you know, that Wokingham has a five-year housing land deficit, and the site will make a contribution to that shortfall. To conclude, there are no valid planning reasons to refuse this application. The officer makes this crystal clear. I am well aware that the objectors and the 2 councillors have long-standing issues with the landowners, but that does not represent a planning reason for refusing the application before you. I hope the committee will follow the officer's recommendation and we can build a quality, sustainable development with our established team of local builders and craftsmen. Thank you very much indeed.
Charles?
Thank you. Chair and committee, first of all, to respond, there are valid planning reasons why this should be refused. It's in the countryside, it's outside the settlement boundary in the 2010 and 2022 draft local plan. It's also not in the Finch Hampstead NDP. As Councillor Marshall-Say has pointed out, the last appeal, the inspector stated very clearly this site was unsustainable. So this is a site which does not comply with our planning policies, and a planning inspector has called unsustainable, which officers are recommending for approval. It would contribute 5 houses to the 5-year land supply. For what? 500? 5. I wanted to talk to the committee about the process with this application. In October 22, I received an email from enforcement officers saying enforcement was ending as a verbal planning agreement had been made for housing. November 22, I received a phone call from a senior officer. This officer told me an application was imminent and it would be difficult for the council to defend because of the lack of a draft local plan. Later in December, I was contacted by several residents with concerns in particular over the consultation. Officers advised me they'd written to 51 residents. Of the 18 residents I've spoken to myself, not one has received a letter. I raised this with officers who agreed, in fairness, to extend the consultation until January the 9th, but this still leaves 33 local people who border this site who have not been consulted and may well not be aware that we're even here tonight. This application was obviously listed for committee 2 days after the consultation had ended. I asked officers and senior members to delay the planning committee and was refused. We arrive at this hearing with resident questions not answered, planning conditions not clear. Some are specified in the document, but residents are asking for more. This council is meant to defend its residents rather than seek the most convenient way to push through favoured planning applications. I would ask the committee tonight to please consider deferring this application till the next planning committee to allow time for my residents to be able to negotiate and discuss planning conditions with officers and try and come to a place where they feel comfortable to accept it. Residents deplore the behaviour of this applicant, the blight he's placed on their lives, but they have real concerns over the way the council's handled this application. They're realistic about the fact that the local WBC local plan is on hold. They have decided and have asked me to say that with great reluctance, they do not oppose this application and have They have submitted a list of planning applications to officers to try and protect their interests. In fairness to officers, I submitted this on Monday and they have engaged positively with me. But due to this hearing being on Wednesday and the consultation finishing on Monday, there has simply not been enough time to get to the bottom of them, hence my request to consider deferring the application. The officers have included some of these conditions which is noted, but my residents do expect these will be enforced in full if the applicant deviates from them as they have done in the past.
Members wishing to speak? Becca? John?
Thank you, Chair. Just for the record, and as a result of one of the comments made by one of the other speakers earlier, I don't know the applicant. I'm aware there's been planning issues on this site, but I've never met him, and therefore I'm not swayed in any way by any personal opinion of him. When you read through the officer notes on this, as a summary, it clearly states that the application still contradicts a number of the core policies, CP11 foremost amongst them. And the actual summary basically says it's no different other than the number of houses to the previous applications that were made and turned down on appeal. The only difference now is that the land supply numbers are working against us and we're probably going to lose an appeal on the tilted balance. And it's that simple when you read the document. However, if you look at the the National Planning Policy Framework in Section 2, paragraph 14, where it talks about the impact of neighbourhood development plans, which were already agreed in this instance, at least moderate in strength, and I would argue of increasing strength, given the state of the Finch-Hampstead neighbourhood plan. The NPPF states, in situations where the presumption in favour of sustainable development applies to applications involving the provision of housing, the adverse impact of allowing development that conflicts with the neighbourhood plan is likely to significantly and demonstrably outweigh the benefits. In other words, there is a tilt back against the tilted balance in this instance, should the council choose to apply it. And I would urge officers to double check that and to understand that more fully. However, I am cognizant of what Councillor Margetts has just said in terms of a deferral, given that the residents seem to have removed or at least mitigated some of their objections. And I'll be interested in what the rest of the committee have to say about it.
Becca?
Thank you, Chair. Number one, this is development in the countryside. Yeah, we're saying it. We've got officers telling us this is departure from policy. Number two, I do have concerns about the process that's been followed here. Personal experience, this obviously cannot be considered, but of residents not being notified. I wonder if I could have some clarity on that, please, about whether residents and people that have previously made comments on this application, they should have been notified. Has that actually happened? Can we have some clarity, please?
51 residents were notified. I've checked that and I've checked the process that occurred. I cannot explain where people have not received notifications, but they've left the council.
Can I just say that this actually happened with another application? So I do have concerns. I mean, what can we do to address this if we clearly have residents that haven't been contacted regarding this?
Residents here.
Oh, we have to stick to this application, unfortunately, not another application that wasn't done right.
I understand that, Chair, but we are trying to follow a process, a democratic process where local residents feel that their voices have been heard, and there appears to be a concern here that hasn't happened.
Just to clarify, the statement of community involvement requires the council to notify adjoining landowners. So in this case, that would be properties in Tomlinson Drive and the applicant's own property at 6 Johnson Drive. So this has gone to 51 properties, primarily on the basis that there is a long history with the site and there's community interest. So there have been 15 submissions. Residents are aware of the application. There has been consultation occurring, and that's occurred in accordance with our statement of community involvement. And so we've followed due process. The issue has been that residents have not received consultation letters, but they've left the council. Whether they've been received by residents, we're not in a position to comment further. But it has been extended beyond the 21 days to include another 10 days after that. So in our view, the council's done more than what they're obliged to do under the Statement of Community Involvement.
John?
Yeah, it's just a number of issues. I mean, I think 5 houses in the scheme of things is relatively small when you look at our current 5-year land supply, but not having a local plan definitely would have. I've had experience of development in my own ward, which was outside the curtilage, urban curtilage, and also was in countryside, and that was allowed, and we did have a 5-year land supply. I'm somewhat confused by the comment about 5 houses being important to land supply. I don't think it possibly is. It's probably irrelevant in the scheme of things. Could you just tell me whether you feel it's not?
Would you like to reply?
The tilted balance requires consideration of the application, regardless of how many houses there is. So there's 5 houses coming forward. The assessment considers the harm posed by that and then weighs that against the benefits. So the benefits in this case have outweighed the harm.
Wayne?
Simon, I presume the High Court challenge is based on the 25.
No, the High Court challenge relates to enforcement appeal from 2022 for the car storage use.
Oh, okay.
And the builder's storage use. So the High Court challenge relates to the inspector's findings in relation to the car storage.
Fine, thank you. I understand what Councillor Margetts is saying. What I'm struggling with, considering the size of the agenda tonight, why we made the decision not to. I mean, I understand, Simon, fully understand what you're saying, but, you know, we've just gone through a situation with the post where, you know, a lot of the days in between the dates that we're talking about, we had strikes. So getting post out to people, etc., would have been very difficult. I'm just struggling why this extra week or so was so important to bring this here this evening. I just don't understand it. I mean, the other thing is, what I don't understand right now, because I don't know what these conditions are that residents are seeking, should I say, and how material they are, and can they be settled. I mean, I know this is not a planning, in essence, a planning committee, but I'm just trying to work backwards and how we can help our residents, how they will impact on the decision, and can something be done through negotiation with the officer before it comes to the planning committee. But let's not, I mean, I agree with both Councillor Cornish and Kaiser. This is an unsustainable site, whether it's 5 or 200. It's CP11. 5 are not going to change our 4-year land supply. Yes, we've got a problem with our local plan, but in this instance, you've got a neighbourhood plan that carries moderate weight, which should be taken into account. So all of those things are in sync with what 3 other councillors have said. What I'm interested in is this urgency to bring this here tonight, and why we didn't allow that extra time so we could have resolved some of the issues we're hearing in the room tonight.
There's 3 primary reasons for that. One is within the 8-week time frame. So if it fell outside the 8-week time frame, they're entitled to appeal a non-determination. That would have occurred if it went to February committee. There is, for convenience, there was the previous application was 6 Johnson Drive, so this is accompanying that application. And the third reason was that the High Court challenge was to expedite the process within proper means, which it has occurred, to allow a decision to occur for this application to resolve the High Court challenge matter prior to its hearing in beginning of March.
I understand that, but so if this hadn't have had a High Court hearing pending, you would have felt comfortable going to the agent and asking for an extension to exempt you from the 8 weeks determination period?
I haven't put my mind to that, but the consultation, from our point of view, the consultation period ran, it ended, and I prepared a report for the committee, all within appropriate timeframes. Residents have become aware of the application. I've become aware of, in the interim period since the agenda's been set, of conditions that they've sought. I've responded to those queries. Some of the conditions wouldn't meet tests, the 6 tests of applying conditions. Other conditions are already imposed in the draft recommendation.
Sorry, can I just come back on a totally separate question? The site, would you regard that site as a brownfield site?
The brownfield is previously developed land, so that relates to structures on the land. So you'd only, and this came up in the 2019 appeal decision as well, you'd only get to 5-10% of the site being brownfield because of the buildings. So everything else on the land is structures and is vehicles and storage, most of which has been removed. So it's mostly greenfield.
Thank you.
Okay, Andrew?
Thank you, Chair. I believe that this application is different in many significant ways to the previous application, including a large reduction in the number of homes and all the attendant consequences of that, the inclusion of wildlife corridors around the perimeters and so forth, as examples. However, the issue of sustainability, which figured prominently in the Planning Inspectorate's decision, has not changed substantially, with the caveat that we are now talking, if should this be approved, of a significantly reduced numbers of homes. Now, whether or not that impacts on the sustainability argument, I'm not sure. We must apply the tilted balance in our consideration, and we must acknowledge that the presence of the tilted balance now significantly weakens the reasons why the previous planning refusal was upheld. But the question which I have for officers, and which I'm still not sure about, derives from Councillor Cornish's reference to the role of neighbourhood plans. And I do stand corrected. Thank you, Councillor Cornish. Okay, in the supplementary agenda, the neighbourhood plan is now given a moderate weighting. So my question to officers is, to what extent might that have an impact on the tilted balance?
Sorry, can I clarify the question? Sorry.
So the question is about the role or impact, potential impact, that the now moderate weighting that the neighbourhood plan might have in the consideration of tilted balance.
To clarify with the neighbourhood plan, I have made the comment that it attracts moderate weight based on the fact that it's at its examination stage. I would suggest that I've been incorrect in that sense. Our policy department and Brian can back me up in that situation, that policy have indicated that it is still attracting limited weight. In any event, the policy is consistent with the CP11, and there is a departure that we're acknowledging, and the tilted balance applies.
If I could just jump in, Andrew. So just to give a bit of background, as a number of members here tonight will be aware, obviously the Finchampton neighbourhood neighbour development plan is currently being prepared, and the consultation of the draft plan, the Reg 16, was conducted recently. I think it concluded in the end of November 2022, and it's now progressed to its independent examination stage. So the plan, it contains a number of policies, obviously relevant to housing, settlement, separation, and so on. It proposes to allocate 2 sites, that's clear, 4 dwellings in total. It also proposes to allocate areas of land for local green space. Given, and this is the most up-to-date information we have been given from our planning policy team as of 2 days ago, given that the neighbourhood development plan is still at examination stage, and the extent of unresolved objections not being known at this stage, it has limited weight in the decision-making process at this time. The words moderate weight has not been provided to officers in any official capacity from the policy department. Okay.
Al?
Yes, on the question of residents being consulted, there's been postal strikes and a lot of delays. Should we just test whether the committee want to defer this to the next month? If that's a formal proposal.
Is that a formal proposal?
I will propose that we defer this item till next month.
Brian, would you like to comment?
Yeah, just sorry, before you move seconding, or anyone moves to second that, just to clarify, the council, obviously we've made clear in our officer report and as communicated to a number of councillors, we have fulfilled our statutory duty on publicising the application. Obviously, there has been a considerable amount of feedback from the local community via the planning application, through representations, through correspondence, obviously through even attendance here this evening, but the extended consultation period to the 9th, which is the maximum we could possibly give, and we were happy to do so, took into account what most of us would agree was an unprecedented period of postal disruption. And I know, so from personal circumstance, I'm still receiving Christmas cards today. But irrespective of that, the application and the council, in fulfilling its duties, have done everything that they need to do to notify about the application, to defer the application, or for the council officers to decide to delay the application with the risk of an appeal that may bring to, for example, the February planning committee meeting, would not result in any change in material circumstances or introduce any new evidence within the report that's presented based on those representations already received.
Yeah. In view of that information, also about the 8 weeks,
we'll just confirm the determination date, but if members do defer the application, 25th of January is the 8-week date. If members do defer the application from this evening, there obviously the applicant is at liberty to appeal a non-determination on the application.
Al, do you still wish to go ahead?
Well, I would, because I mean, the feeling in the room seems to be that that regardless, that there seems to be residents who haven't been consulted, and they ought to be able to put their case somewhere.
Could I just ask something? Sorry, we did defer something at the last planning committee, another item, and there was the possibility that that could be non-determined as well. We were happy to do that. I mean, when I look at these letters here, it does state that the consultation was consulted from the 5th to the 28th of December, and there's only these 11 here. So
This has already been covered, unfortunately. Do we have a seconder for Al's? Motion.
Can I just ask a question before I support Andy? Understand what you're saying, clearly understanding what you're saying. Question I would ask of the officers, I would ask if the applicant did go for non-determination, would you offer any defence against that at an appeal?
Thank you, John. If any applicant appealed non-determination and the item was due or required to be determined at a planning committee, so for example, a major application for approval, recommended for approval, for example, we would bring the application to a committee in any respect to get a kind of a motion from the council as to what the recommendation would have been in order to either defend or not defend the appeal. So a scenario in this case would be an appeal is received for non-determination. The application is brought to the next committee with most likely an incredibly similar report to what we have now. There'd be no new information requested on behalf of members, unlike the previous committee where deferrals were deferred for requests of additional information, in which it would be in the applicant's interest to provide that information. Here, the application is being deferred for, by the sounds of the concern identified, for publicity reasons. The application publicity would be undertaken in the time. A possible appeal might be received against non-determination. The council would not, again, at the moment we have an officer recommendation for approval. If members at the February committee voted to refuse the application, or they would have refused the application, then the council would defend that council recommendation for refusal through the appeal. Does that make sense?
Yes, in part it makes sense. The question I guess I should have asked you in a slightly less controversial way should have been, do you think there are any grounds for deferral of this application?
On the basis of publicity, there is no grounds, procedural grounds for deferral, because the council has fulfilled its statutory duties.
Okay, just what's the wording that you want to, the reasons for deferral?
So the residents can, who obviously feel they haven't had a chance to have their say on this, can have their say.
Is that a valid reason?
Hang on, publicity.
Al, to allow additional consultation with residents to be undertaken? Is that satisfactory?
Yes.
Okay. Do we have a seconder for this proposal?
Sorry, Chair, could we ask, is there a legal person here that we could ask? Could we ask the legal person what they've...
We do have a legal person on. Lindsay, could you give us an opinion, please?
Yes, I can give you an opinion. I think the committee have to bear in mind that everything has been done that is required of it with regards to publicising this application. To defer to allow for more consultation, I have concerns because that opportunity has been given. I can't comment on who has and hasn't received notification, and I'm also not sure on this occasion if site notices have been put up, which is another way of actually notifying neighbouring residents. So I do have concerns to defer on this basis. If members were inclined to proceed, you do risk non-determination being the appeal, this application being appealed for non-determination, and that is a risk to the council.
Please don't interject, by the way. In light of that legal advice, do you still want to second the application? Okay. Wayne, I have a couple more comments from Wayne and from John.
No, if you think back to my question, what I was trying to ascertain was what are the points that is the issues and could those issues be resolved? I mean, I don't know if people fully appreciate that this isn't like a pick a mix. An application goes in and then you can start sending notes in saying, I don't want this, don't want that, don't want this. And then you decide what you want and you can send recommendations through. I think, but let's just look at the procedural point here. I understand what Lindsay's just said, but the actual determination date is the 26th of January, correct?
25th.
25th, all right. I'll give you 24 hours. We're talking 11 days. Do we honestly believe that somebody is going to go within those 11 days to non-determination? I understand what Brian said, and it's a very valid point. It comes to next planning committee and it's refused. But I think on the grounds of public interest, I would support.
John, short comment if you want.
No, I got my answer from the link.
Therefore, we have to go to, you still 1 second, okay? Yes, therefore we have to come to a vote for this, for deferral. All of those, for the reason that Alistair supplied. Yeah. And it has been deferred. The next application is 22963 72 Sutcliffe Avenue, Early. Are you leaving? Heather Paxton, the agent. Kieran is the officer. Would you please present?
Thank you, Chair, and good evening, members. So this application is for 72 Sutcliffe Avenue in Early. It's a part retrospective application for the proposed insertion of a dormer window into the existing loft conversion and associated roof alterations. So this application is a resubmission of a scheme recently refused in September 2022, and that being application 221978. This application was refused on the grounds that the dormer, by reason of its contrived squared off design with the gable roof, was out of character with the character of the area. My key has just broken on my keyboard. I do apologise. So the amendments made to the scheme following this application consist of the dormer window being set in from the side of the dwelling's roof and reinstating the taller hipped roof form of the two-storey side extension approved under application 202186. The revised dormer design is considered by the council sufficiently proportionate to the host dwelling and demonstrates a number of essentially it complies with a number of the Borough Design Guide's recommendations for a dormer of its style. Extension.
Is it not? Presentation's not running.
I do apologise, members. I don't know what's going on there. Apologies, guys. So I will backtrack a little bit just so everyone can see the presentation properly. So this was the original application with the squared offside elevation with the gable. As I said, this was refused due to the detrimental impact on the character of the area. So the current proposals get rid of this squared offside elevation and reinstate the tall hip to roof form of the two-storey side extension approved under application 202186. In our view, the revised dormer design is sufficiently proportionate to the host dwelling and demonstrates compliance with a number of the Borough Design Guide's recommendations for a dormer of its style. And as can be seen in the 3D image displayed, it's also very in keeping with the form of other flat roof dormers in the area. So in terms of neighbouring amenity, the constructed dormer overlooks the roof form of the adjacent number 22 Meadow Road and part of their rear garden with a minimum separation distance of approximately 16.5 metres from the nearest impacted roof light on number 22 Meadow Road's northern side elevation and the nearest rear garden. Page 47 of the Borough Design Guide outlines the minimum separation distances to maintain privacy and limit sense of enclosure. And for dwellings for over 2 storeys, the back to flank distance recommendation is a minimum of 15 metres, which the proposals are clearly compliant with. Furthermore, the roof light that would be impacted is obscured, so the overlooking opportunities as a result of this would be negligible. 2 ground floor windows also exist on number 22 Meadow Road's northern side elevation. One kitchen window and a bathroom window, which is obscured. As the bathroom window is obscured, overlooking opportunities for this one are also negligible. With regard to the kitchen window, the height of the dormer, in our view, would provide only very skewed views of this window, which would not be unacceptable. Furthermore, the separation distance between the bathroom and the kitchen windows is also a minimum of 15 metres and therefore compliant with the Borough Design Guide. Therefore, subject to the conditions and informances outlined in Appendix 1, this application is recommended for refusal. Apologies, recommended for approval.
Just lost the application over. Heather Paxton, the agent.
Thank you. I did have some slides. Thank you.
Okay, would you proceed now with these slides?
Okay, thank you. So just to reiterate a few points that Kieran made and to give you a bit of background to the site as well. Planning permission was received in October 2020 for the proposed extensions and alterations that you can see here. What was included in that planning application was the conversion of the loft with 2 Veluxes in the front and rear roof slopes. If I could have slide 2, please. When construction began, my client, believing that the further addition of a dormer window would be covered under permitted development, actually went ahead and constructed the dormer as shown in the photograph here. Through the construction process, there's actually been numerous complaints made, some resulting enforcement cases raised, which have actually all been dealt with and addressed in a timely manner. My client has been fully compliant throughout the process, but I would note that it drew out the construction time by approximately 6 months with all the delays. Seeking our advice, we put in a retrospective planning application for the dormer, which, as Kieran stated, was refused due to the way it was constructed. This new application seeks to rectify that dormer design and ultimately allow it to conform with local planning policies and the Borough Design Guide. Slide 3, please. A separate issue to this, but I think an important planning consideration was the error in the formation of the roof to the actual new 2-storey side extension. This wasn't actually constructed the way it was originally designed. In my proposed view below, The idea is that the original design is actually reconstructed, which would further obscure the view of the dormer, making it more subservient to the host dwelling. All positive changes which have been acknowledged by the planning officer in his report. Slide 4, please. From the time construction has begun, there's been general animosity from neighbours, canvassing of neighbours, which can be seen here, and a general feel from my client of a hate campaign against him and his family through the development of their family home. I would ask that the above application be considered solely on the merits of the information provided here, rather than being judged by the way the construction has actually taken place on site. Thanks for your time.
All right, Mike and Norman are going to share for 3 minutes, and I'd like to make a statement to this particular point that please, if you want to speak at the committee, will you please not wait till the day of the committee to do this? Will you do so in advance, like we requested before? Thank you. Mike goes first, and then Norman will go second.
Thank you. As ward council of this location, I've asked for the application to be brought to this committee because it does not comply with policy CP1, CP3 of the core strategy or R23 of the borough design guide, nor does it meet the design guidance. And some of the information just given is not what I believe is in the plans. I would like to bring a number of observations to your attention. The summary fails to mention that the dormer was unlawfully built and is the third attempt to regularise it as a result of enforcement action. It fails to mention that the plot is highly prominent and elevated, and that the dormer is clearly visible from 120 metres down the adjacent road, Meadow Road. It fails to mention the approved roof lights were not installed as per the plans. They should have been installed on the rear. They have been installed on the street facing elevation. I do not believe they were part of the original planning. The planning statement states this is not a material consideration. Surely it is, as it affects the street scene. The summary and item 2 under the planning issues on page 118 both state incorrectly that part of the proposed work is the reinstatement of the taller hipped roof form of the side extension. It's not a reinstatement because it was never built properly in the first place. It states that the revised dormer is now considered proportionate, but fails to mention that the 6.5 metre width of the unlawful dormer is modified on only one side by just between 150 and 200 mil. Nothing else is proposed to reduce the massive scale of this dormer. It fails to mention the additional 20% of the whole of the garden of the rear of 22 Meadow Road, which is now visible from the dormer, clearly a loss of amenity. The borough design guide states that door windows should generally be positioned within the main roof with it being set back. Moving one wall just 150 mil will not make it proportionate or a subservient
Mike,
feature.
could you possibly sum up now?
Yes, I would request that the committee carefully consider whether moving one wall just 150 mil completely overturns the reason for the previous refusal, which used the words, its contrived design, flat roof, elevated, prominent corner position is out of keeping with the post dwelling. That wording still applies. It should be refused. Thank you.
Norman, you'll have a minute and a half.
Hey, thank you very much. Just share this with Mike. I'm also one of the borough councillors for this ward. It is still out of character with the area. It's a very, very dominant site. And I think, as Mike has said, the changes are pretty minor. And I think the original refusal should still apply because of that. The secondary issues are overlooking. It's a very prominent site, and it overlooks a large number of the properties further down the street. If you take photographs from further down the street, it's really dominant, and hence overbearing for all the residents round about. So I would ask the committee to consider this very carefully. I really don't think it's the sort of thing that we should be approving. I'd be surprised if it complies with planning policy guidance. It really looks pretty awful, to be blunt. Thank you.
Okay, members of the committee? Andrew?
Thank you, Chair. I share many of the concerns raised with respect to this site, including its retrospective nature of this application, to address what may well have been some unlawful works. However, most works have been approved under previous applications and so cannot be revisited. My understanding, also alluded to by the agent, is that the intention of this current application is to make compliant other works that have been carried out. Some members of this committee and of the public might not be happy with what is compliant, but we can only follow current policy and guidance. If the committee approves the application, the applicant would have an opportunity to follow what is in the current application and hopefully draw an end to what has been a very long and tortuous history of planning and enforcement issues on this site. It would not resolve some of the legitimate concerns that have been expressed regarding matters such as the bulk of the works, overlooking and impact of the character on the character of the area, including the prominent position, corner position of this site. But these are, very unfortunately, matters that are no longer up to deliberation. For these reasons, I will be voting to approve the application. But I wish to make it very clear that I strongly disapprove of the approach by the applicant and hope that they will come to appreciate that it's always in everybody's interests for the proper procedures to be followed.
Yeah, this is not dissimilar to the ones we've had earlier, is it? Where to mitigate or to avoid further enforcement action, officers have agreed with this applicant that this is acceptable. So I would suggest that if the application had been submitted on the basis of what's here, the officers would have recommended that for approval as well. The problem is, as I've said before, I don't like retrospective, but the rules are wrong. The rules are wrong. If you do something and you can stop the enforcement by submitting a planning application. And if you then work with officers of the council, it's a very difficult situation if you then refuse to give planning permission on the basis of the officer's recommendation.
Any other members wishing to speak? So, okay, hold it.
Thank you, Chair. Listening with interest to what's been said, and particularly to Councillor Smith's comments earlier, is he right in saying that what has made this application acceptable, whereas the previous condition was unacceptable, is simply moving a wall 200 millimetres?
Kieran?
Yeah, I do appreciate it. It is a very small reduction, but this small reduction is what achieves compliance with the Borough Design Guide. That is, it is a very small reduction, but regardless, it does demonstrate compliance. The main issue was it being set in from the side of the roof, which it now is. It is also set down from the ridge height of the host dwelling. It's set in the main roof of the house, which is therefore compliant with it. Flat roof dormers are not necessarily in keeping with the main roof of the house, but they are a common characteristic in the area. Immediate locality, there are plenty, as you saw in that 3D image. So yes, I fully appreciate it is a very small reduction, but it is a reduction that achieves compliance with what we see as acceptable in the Borough Design Guide for a dormer of this style.
Wayne?
Kieran, would this, I went for a certificate of lawfulness on this dormer, would I get it?
They originally applied for a dormer, so the side extension was constructed first, and so the resulting roof space exceeded 50 cubic metres when you combine the side extension and the dormer, hence why it was refused. So if they applied retrospectively now for a certificate of existing lawfulness, it would be refused because of the resulting roof space exceeding it when you combine that with the side extension.
Okay, thanks.
Any further questions? Okay.
Proposal.
The proposal at this point is to approve the officer's recommendation. All those in favor? Seconder? I'm not. Andrew's proposed. Okay, can I have a seconder, please?
To accept the officer recommendation.
to accept the current officer recommendation. For approval, okay? Seconder?
Seconder.
I'll second. Now we go to the vote.
In favour?
Those in favor? It's been approved. Okay, Kieran, would you like to present? This is
Yeah, your microphone's not on.
This is application 222-170-17 Byron Road. Kieran's presenting.
Thank you, Chair. Can everyone see this presentation this time? Right, thank you. Lovely. So as the Chair mentioned, this is for application 222-170 for 17 Byron Road. Now, this is a householder application for the proposed erection of a single-storey front and side extension, two-storey side and part two-storey part single-storey rear extension with one dormer window, rear patio and changes to fenestration following the demolition of the existing detached garage. And as you can see, this application is retrospective. It's also worth noting that additional comments from Early Town Council were received this morning, and their objections largely mirror that of their comments made on the 5th of October during the last reconsultation, except for further concerns regarding the proximity of the two-storey side extension to the neighbour and the fact that the revised internal width of the proposed floor plans, in particular the two-storey rear extension, is not indicated on the plans. However, it should be noted that the revised internal width is in fact indicated on drawing 06P16. So from this slide, you can see that this is the first application that came through in January 2021 and was the start of a number of alterations that happened on this site. This approved the single-storey side and front extension, two-storey side and rear extension, and the single-storey rear extension. The other notable permission was application 211682 for a certificate of lawfulness for the proposed erection of a rear dormer and one roof light. At the time, when the decision was issued for approval, the applicant was advised in an informative that they should seek advice as to whether the both approved schemes, those being 203-275 and 211682, could be lawfully implemented together. As if the 203-275 extensions were constructed first, it would render the approved dormer unlawful. The dormer, as can be seen in the photo on the slide, began construction before the side extensions. However, the south-facing side wall was not constructed to allow the construction of the side extensions. As the dormer was not fully constructed in accordance with the approved plans, it was rendered unlawful. Therefore, its design and subsequent impact is therefore a relevant consideration in the determination of this application. So these are the current proposals, as can be seen on the slide. This application encompasses all the previously approved additions on site into one scheme, as there were a number of inconsistencies and elements of the proposals that weren't built in accordance with the originally approved plans. The changes made to the originally approved schemes that are subject to this application are outlined in paragraph 15 of the committee report and the supplementary agenda. It is important for members to note that this application should only assess the changes to the proposals outlined in the report and the supplementary agenda. All other elements should not be subject to further assessment. So the changes made are largely to the rear and in the council's view insignificantly affect the character of the area. The omitted flat roofs, the flat south-facing flat roof elevation of the dormer has been replaced with the hip roof of the side extension, which is actually considered a visual improvement on the dormer side elevation that was originally approved. It is much more subservient with the host dwelling and the roofscape of Byron Road, which is predominantly visually dominated by hipped roofs. The dormer's flat roof form also reflects the design of other flat roof dormer loft conversions seen on the street. The only element that would be mainly visible from the street is the flat roof dormer protrusion on the front elevation, which can be seen in the top two photos. It is agreed that by the council that it is slightly incongruous, but however, it is very modest in size and it is not considered to be unduly overbearing as to detrimentally impact the character of the area. There would be some harm, but it would be very, very localized and it is not considered enough to substantiate a reason for refusal. Overall, the changes to previously approved schemes are negligible and would not cause any adverse harm to the visual amenities of the area, nor the amenities of the adjoining occupiers. Subject to the conditions and informatives outlined in Appendix 1 of this report, this application is also recommended for approval.
Okay, Tim Marsh, AC Residents Association.
Thank you, Chair. Good evening. Our Residents Association supports on the following grounds: inappropriate mass, build form, materials and character of the area, plus the detriment to amenity of adjacent land users and their quality of life. Now, those are all words taken from policy CP3, which this application contravenes. This is a retrospective application due to the development exceeding the constraints of previously approved plans. Now, you've heard from the planning officers that the differences don't matter are within planning rules. There are points in the planning officer's report, the full planning officer's report, which have been individually countered by residents. Now, we know that the residents' point do not appear to have been made available, and yet planning have attempted to counter some of these points in the supplementary agenda by stating the following, and I'll number them for you. 1. Non-matching bricks will weather and blend over time. This is fundamentally untrue. Bricks, unlike tiles, are designed to retain their appearance. The textured and dark bricks used will never change to the smooth, pale red used on the original property. Point number 2. The dormer, visible through kitchen roof light of the neighbour, is not overbearing. This entirely misses the point that the resident's kitchen can be seen from the dormer. It's a privacy issue. 3rd, single-storey rear protrusion is minor and has no adverse impacts. Now, this protrusion of a 3-metre high wall extending almost 1 metre casts a shadow onto the sun terrace built at the rear of 19. So therefore, this is a loss of amenity. This would have been evident from the updated shadow diagrams, which planning state were not necessary. The 45-degree diagrams supplied indicate ambient light levels, not direct sunlight. Direct sunlight has consistently been the issue for number 19 due to the direction of sun's travel, which comes from the direction of 17. Now, the noise from the fans is not a planning issue, they say. Now, since when has noise from neighbouring premises not been a planning issue? It is considered when loading and unloading delivery trucks, etc. The dormer. This has voided the condition, as we've heard, and is therefore reassessed. Now, it's important to note that this was originally applied for as a permitted development. If this is now void.
Sorry, Tim, can you just, you were muted there just for a second. If you appear to be muted. It's only the last 10 seconds. I've paused your speech. Try speaking again.
Where did I?
You were speaking about permitted development.
Right, can you hear me now? where are we? Sorry. Ah, yes, okay. The dormer. This has avoided the conditions we understand and therefore being reassessed. Now, it was applied for as permitted development. If this is now void, it comes under WBC rules and guidelines. Now, there are precedents for these very large dormers which distort the roof lines to be refused by WBC, including one in Byron Road. And I quote from, there's several of them, but one of the planning officers said, these are intrusive, excessively bulky dormer extensions resulting in an inappropriate design of roof form that will detract from the established character of the area and a negative impact on the main building. So, so to summarise, the objections raised by the neighbours are evident to everyone who's been to site and seen the development in context. ASA asks that this application is judged against Strategic Policy CP3 and refused. Thank you.
Yeah, councillors, I'm not a public speaker, so please bear with me. I'm a civil servant working for the Home Office with 20 years service. My wife is an administrator with over 15 years service. We are a hard-working and law-abiding family. We absolutely wanted to follow the various rules and sincerely apologize for the minor mistakes that may have been made. We were at the mercy of the architects and the builders. We were extending our home so that my elderly parents could move in with us. My father is 86 years old and my mother is 77 years old. Unfortunately, my mother is disabled, has limited mobility and suffers from dementia and Alzheimer's disease. She requires a lot of care that my father cannot provide. The extension includes a bedroom and an accessible shower room on the ground floor for my parents' use. We do not want to burden the local authority, Wokingham Council, with their social care. The extended home allows the family to have their own personal space. My daughter is currently in year 11 and is revising for her GCSE exams in a couple of months' time. My son is in year 9, going to start his GCSEs next year. My parents require living quarters that are suitable for their age, medical and limited mobility needs. I can show you evidence, if required, of my mother's disability and medical condition. The extra space also potentially provides us the option in the future for foster care. We have done everything that has been requested of us in regards to making the build lawful. The structure currently standing is now as per the permissions originally granted. The resubmission we feel has resolved the minor discrepancies that may have been there. The planning officer has been tough with us, but fair, and I understand he's recommending approval. We as a family humbly request that you approve the extension. Thank you for your time.
Thank you. My name is Andy. I'm one of the ward members for Promotion Whitegates. I want to focus on the impact that the development or the application has on the residents at number 19. I visited 19 to have a look from their point of view to see what the actual impact was rather than relying on the diagrams. There seems to have been a history of plans put in which haven't necessarily reflected the reality of what's been built. So I'm not an expert on this sort of diagram, but I would take anything that's put in front of you from this application with a massive pinch of salt. I do recommend that the committee perhaps defers this application with a view to visiting the site so they can assess the impact on the residents themselves. What's not really come out of any of the reports is the importance of the rear of the property at 19, where the primary living area is impacted by the extension, and it's impacted in two ways. It's impacted via there's a roof light in the living area at number 19, and that is dominated by the extension. Not just in terms of what you can see, but in terms of the light which comes into that primary living area at number 19. The second way in which those residents have their utility impacted is via the sun deck patio type thing they've built at the back. That is now in shade. That will lose its direct sunlight. So there are two very, very clear examples where there's been loss of amenity to an existing resident. They have a sun terrace which won't receive sun, and they have a roof light that won't be getting direct light. So I would like to see the application refused. If you won't refuse it, then please do consider a deferral so that you can visit the site yourselves and see for yourselves what impact this has. Thank you.
Andrew is the first person to speak. Does anybody else want to speak as well? Yeah.
Yes, thank you, Chair, and thank you to everybody who's spoken thus far this evening, including Mr. Vigg for sharing some of the context, relating to this this application. Though, unfortunately, some of that, is not really a material planning consideration. But thank you, nonetheless. We are only able to consider the changes that appear in this application, not earlier works and the consequences, the impacts of those on matters such as amenity and the character of the area. The only changes, and only these changes can only be assessed tonight in terms of planning policy and guidance. I do take on board the comments that Councillor Croy has made with respect to impacts, likely impacts on number 19. But I think we have to assume that any such impacts are the result of the whole of the development. And I think we have to assume that it is unlikely that anyone would be able to separate out the impacts of specific changes in this application on that neighbouring property. Because I think that's the crux of the matter, here. We're talking about changes yet again, okay, to try to make an application compliant. No matter what we might feel, about the development as a whole, the matter in front of us now, okay, is to look at the specific changes that are being proposed in order to make this compliant. And because I believe it's highly improbable that a site visit would in any way allow us to separate out the impacts of the changes to this application on the neighbours, possibly wider locality and so forth. I cannot support I cannot support any proposals for deferral for a site visit. And I think that for the reasons that I've outlined, I believe I will have to vote to approve this application. Thank you.
Wayne?
I just mentioned to John Kaiser here, I can't remember the amount in the last 7-8 years where we've had so many retrospective applications come before this committee. And this isn't for this, but we've got to take away from this, because this costs us money. Enforcement costs us money. And if they're not building stuff, because I feel for Mr. Vigg, he's put his faith in an architect and a builder, and they've built it wrong, or whatever they've done wrong, to not to the specification that he thought he had planning permission for. And whether they've used an external building control company or whether they've used ours, I know the majority of people use private companies because they're a lot cheaper, but there's sometimes a reason why things are cheaper, because they don't follow everything like we would at BC Solutions. So I do think we have to take that away from this planning committee. This is causing us far too much work in this council, and for costs that we don't recover. That all has to go to the taxpayer, because you don't get any money back for all the time you have to keep going back and forth on planning applications. For enforcement visits, etc. But with regards to this application, can I refer back to page, sorry, of the lovely colour booklet we had? Page 1, sorry. 170. Sorry about this. Yes, sorry, 171. So number 19 is, sorry, if you look at the top photograph, sorry, there, Kieran, that's number 19. So number 19 is top right. That's right. Is it right? Number 19?
I haven't got the photo back in front of me right now. Someone please pass over.
So it's the one with the little children's playhouse in the garden. That's number 19.
Correct, yes.
Yeah, that's right. Okay, so I would imagine that when the design, Mr. Vig was designing this, he was trying to almost mirror what had happened next door.
There are some similarities, but there are also quite a few differences between the two proposals. But
Yeah.
I see where you're coming from.
But by the these very popular roof lights, roof lanterns, etc. So what we're talking about here, in essence, is the departure away from the original application and the inception of this dormer window, which I think is almost ditto the one we've just had, the previous application. I don't really see what a site visit will do, and I agree with Andrew on that. And I think we're in a situation almost identical to all the words that Councillor Kaiser mentioned on the previous application. We're in a situation of negotiation, and you've put this in front of us this evening. I don't think there's anything we can say that's counter to policy that will make us, well, that we've got a reason to refuse this. But I do go back to my earlier points. We've got to stop this happening in the borough.
Al?
Well, I mean, I take a different view. I mean, I take on board everything that Tim Marsh has said, and Councillor Croy. I mean, we received some. I think a site visit would help, because I mean, we received some photos that aren't in this pack that shows how this door was looking straight into the roof line on number 19. The AC units, I mean, there's no reason why they shouldn't be put down at ground level. I mean, that's just a bit of pipe work, isn't it? I mean, rather than sticking them right outside next door's bedroom window, I mean, that seems ridiculous. The skylights seems to be projecting light directly into their bedroom window. I mean, something surely should be done with that. I mean, at the start of this process, I mean, no one could have thought that the roof form at the front, I mean, it just looks ridiculous. I mean, having the loft sticking out of the front of the house. I just think if this committee rubber stamps this application, I mean, the residents just think we're idiots, really. I mean, I just really can't see that we should be approving this, and I think the applicant should go back and build the thing to how it was first approved.
John?
Yeah, thank you very much. I mean, I don't intend to take anything that the officers tell me with a pinch of salt. I would assume that the officers have actually done the necessary training, and in their opinion, this is what they believe should be approved. I also don't believe this committee rubber stamps anything. There are rules, and the rules are broken. We don't approve. If the rules are complied with, and we have officers telling them they're complied with, puts us in a very difficult situation. I feel, I do feel for the applicant purely and simply because he's been speaking to the officers. The officers have led him down this path. Now, the only question I would ask, there seems to be an allegation that there's a lot more wrong with this, that it hasn't been, that the rules haven't been applied to the previous application. I mean, what do you say about that?
Can you please clarify what these inaccuracies are?
Right. I mean, if you just go to, I noticed the parish council make a comment saying concerns submitted drawings do not accurately reflect the as-built situation.
They did mention that in the previous ones. I did address that at the start. The main issue that they have is the lack of an internal width measurement on the two-story rear extension. I clarified that on drawing 06P16, it is clearly shown as 5.503. It used to be indicated as 5.103, but due to the correction in the inconsistency in the width of the two-story rear extension and its distance from the boundary with number 19, the floor plans originally stated 2.9 meters. The elevations originally stated 2.4 meters. On site, it is 2.4, and that is what that additional 0.4 meters to the internal width shown. It is shown. I feel like this may be simply a misread from Early Town Council because it is clearly shown on the plan.
Okay, so you believe, in your professional opinion, that this regularizes the breaches of the conditions?
I do indeed. We've gone through multiple. I've been to site 3 times now, twice with enforcement officers, and we have measured everything on site. I have been very meticulous when it comes to the drawings, as Manprit is aware. We have gone through multiple emails discussing this, and we have made sure, and I'm confident that these plans are accurate enough to determine at this time.
Thank you.
Rebecca?
My question was answered then, so I won't delay it any further.
David?
Yeah, I mean, the simple fact of this is that dormer extensions into the roof at the rear are generally allowed under permitted development. No one likes them. They're always going to involve a degree of overlooking and a loss of privacy. That, unfortunately, is the way planning law is. And in many occasions, such as this, we end up arguing over technicalities to try and dismiss something that we don't like, but it's sadly almost inevitable. The aesthetics of this are not to my taste, but again, that's not always a planning consideration. The plot is large and will take the size of a house built on it in terms of the garden, so I would be minded to approve it.
Would anybody like to make a proposal?
I propose that we approve the application.
It's carried.
Okay.
We're going to have a 10-minute comfort break right now. I said 10 before.
5 minutes.
5 minutes. We want to do this for equality, diversity, and inclusion. 5 minutes. Okay, we're back in session now. The application we're going on is the Tent House Bridge, and the first person speaking is Imogen.
No. Says Marcus.
Go with the officer.
Do you want the officers to present it first?
Yes, please. That's right.
Thank you, Chair, and good evening all. This is application number 223493, a prior approval application for the erection of a single span footbridge following a demolition of the two existing footbridges at the location of the former Tan House level crossing in Wokingham Town Centre. Members will already be aware that the proposal has been submitted under a prior approval application rather than a full planning application. The proposal benefits from permitted development rights under Schedule 2, Part 18, Class A of the Town and Country Planning General Permitted Development Order 2015. This relates to certain types of development which are authorised by an Act or Order of Parliament. In this instance, a combination of 3 railway acts establishes the principle of erecting a bridge across the railway. This essentially means that the 3 acts of Parliament sit above national planning legislation, and the General Permitted Development Order facilitates the provision of the bridge allowed under these acts. The applicant must firstly obtain prior approval from the local planning authority before proceeding with the permitted development, which is why this application has been submitted. The prior approval process is set out under the General Permitted Development Order, and this is extremely limited. As a result, the local planning authority can only assess 2 considerations in their appraisal of the scheme. Firstly, whether the development ought to be and could reasonably be carried out elsewhere on the land, and whether the design or external appearance of the development would result in harm to visual amenity. These are the only reasons why granting prior approval should be withheld. Due to the limited considerations which can be taken into account under this type of prior approval application, many issues and policy grounds which would normally be at the heart of our decision making are unfortunately not material planning considerations in this instance and cannot warrant a reason for refusal. As shown on the site location plan, the proposed footbridge would span the railways at essentially the same points as the existing footbridges. The eastern end of the footbridge would be located in the ongoing development at Carnival Pool, and with the western end located in Latimer Road Recreation Ground. This location allows the replacement footbridge to continue to accommodate the public right-of-way, footpath 23, which runs through the site. There is a risk that if the current pedestrian route was not utilised and the proposed bridge was to be located elsewhere, that this would involve a longer, more significant footpath diversion. Locations further south along the railway line would require a significantly longer footbridge, given that the railway splits directly into 2 at this point, while locations further north would likely conflict with residential properties and likely to be less preferable in terms of pedestrian flow and east-west desire lines. Hence, it is not considered that the proposed footbridge ought to be located elsewhere or that it could reasonably meet its purpose by being located elsewhere. This slide shows the proposed elevations of the footbridge and a site visit photo showing the current bridges. The footbridge would be finished with stainless steel panels and a non-slip waterproof floor, with the remaining structure steel painted in a grey finish. As with the current bridges, the proposal would be visible from various public locations and seen in the context of the railway below it. This slide shows a photograph of each of the existing bridges. The existing footbridges are not considered to be of a high visual quality, and there is no objection to their demolition. While the proposed replacement bridge would clearly have an appearance entirely reflective of its intended function, it would have a more lightweight appearance than the existing concrete bridge and would utilise modern materials that would better reflect the character and appearance of the surrounding area and in context with the railway line. The choice of materials would also reduce the opportunity for graffiti or other forms of vandalism which, as seen in the site photos, can significantly degrade the overall appearance of a bridge. While the bridge would be a noticeable feature in the landscape, it would not appear out of scale with other existing buildings in the vicinity, including the large multi-storey car park on the eastern end in Carnival Pool. This further mitigates the visual impact of the proposal and would not harm the character of the area. Overall, the design and external materials of the proposed footbridge would be of a good quality that would reflect its urban setting and represent a significant improvement in visual terms to the existing dilapidated bridge crossing. Hence, it is not considered that the design or external appearance of the proposed footbridge would harm or injure the amenity of the neighbourhood. It is not considered that A, there is any alternative location that is more suited to the provision of the proposed footbridge, or B, that the amenity of the areas would be injured due to its design or visual appearance. It is therefore recommended that the prior approval is granted, subject to the informatives included in the committee report and supplementary agenda. The informatives draw the applicant's attention to other matters and remind them of their duty to investigate whether consents or permissions under any other regulatory regimes are required. The supplementary agenda also includes supplementary information from Network Rail received last week. On top of clarifying certain aspects of the proposal, Network Rail have confirmed that a real wheel channel will be installed on the steps for cyclists. Thank you.
Imogen?
Okay, good evening. Wokingham Town Council owns the land on the south side of this railway line at this point, and the right-of-way footpath coming up to the bridge is currently surrounded by allotments and leads on into the housing, creating a convenient walking route to town for people who live south of the railway. I would have thought that in the planning stages for this bridge, Network Rail would have come and talked to Wokingham Town Council and possibly asked us for some land. We have even primed the allotment holders who would be most affected by this bridge, and we would most likely relinquish this land if it meant we were to see a bridge that was fit for the 21st century. Instead, there has just been silence, up to the surprising point where this planning application was submitted. Firstly, we have a problem with the suggested materials being used for this bridge. Wokingham Town Council cleans graffiti from all around the town and is permitted to clean Network Rail property. This bridge is a popular graffiti location, but the suggested material to be used is perforated steel. This is an extremely difficult material for removing graffiti from. Spray paint cannot be removed from the inside edges of the perforations, and therefore the shadow of the graffiti image stays permanent, affecting the visual amenity of this location. We are also concerned that the existing bridge will be demolished without a timeline or a plan for rerouting the traffic that uses it. Network Rail has its own inclusive design standards. There is a very clear state of statutory legislation that requires employers and service providers and other organisations to take positive action to enable existing or potential employees or customers to overcome and minimise the disadvantage arising from a protected characteristic. It is therefore unclear why they would design a 21st century bridge that only has stairs, as it excludes people with prams, wheelchairs, mobility scooters and other mobility problems related to stairs. If the bridge was designed with ramps to meet the needs of the Equalities Act and Network Rail's own standards, it also would meet the needs of those with bicycles and other wheeled transport. Because this bridge application has been submitted by Network Rail, this is a permitted development application, and our normal rules around planning applications cannot be used. If we could use them, we would be objecting using our borough design guiding principles of CP2, inclusive design, affecting children, people and families, ageing population and people with special needs, and CP6, managing travel demand, sustainable forms of transport and improving the existing infrastructure. The permitted development regulations do not allow local planning authority to stop this application, but it continues to allow you to comment and consider matters on such as the design or the external appearance of this structure, especially if it injure the amenity of the neighbourhood and is reasonably capable of modification. I know there are some questions over what design means in this case, but it is certainly listed separately in the legislation to external appearance. I will therefore argue that the perforated steel panels and the lack of ramps are certainly things that this committee can comment on and apply conditions on in this case, as this bridge can be modified to suit the needs of its neighbourhood.
Okay, who have two residents who are going to be sharing the time, Alex Cran and Natalie Wilson. Who wants to go first?
Hello.
You've got about a minute and a half if you're sharing.
Okay. Okay. Good evening. Thank you for letting me speak. I'll try and be quick. I'm speaking on behalf of Watch, the Wokingham Active Travel Community Hub. Over 30,000 residents of the borough live to the south of the rail lines. Unfortunately, access into the town centre from the south is a big issue, with the only routes being under the bridges on the Finch-Hampstead Road and the level crossing by the station. Both these routes are heavily congested and do not link directly into the main leisure areas at the Elmsfield and Carnival Hub developments. Wokingham is a victim of its own success as a great place to live, with traffic and congestion becoming an increasing problem. One simple solution is to build safe, convenient routes into the town to encourage travel by foot and bicycle. The Townhouse crossing would be the perfect place for a route like this. However, the current bridge will stop this being a viable transit link for all but the most fit and able. In summary, Watch objects to the current design and feels that the council must try and work with Network Rail to come up with a design that includes wide ramps of a gradient suitable for anyone with frailty or limited mobility to safely and easily traverse. In this day and age where equality plays such a rightly important part in our lives, it seems crazy that something as old-fashioned and discriminatory as this bridge can be forced through against the will of so many in the community. Thank you.
Hi, I'm Natalie. I live south of the railway line. I travel actively. I'm a mum to a 2-year-old. I have a disabling medical condition and I have had a brain injury. I travel from my house to the town centre every day for work. My only options to get to the town centre actively are along major thoroughfares which are congested and polluted, and they make me feel unsafe as a vulnerable road user. Now, wouldn't it be amazing if there was an opportunity for me to reach the town centre safely on a traffic-free route? Well, the redevelopment of Townhouse Bridge is it, but this design isn't it. How can anyone design the only opportunity for a traffic-free route to only be useful for able-bodied people without young children in tow? Disabled, mobility scooter users, wheelchair users, pushchair users, disability bikes, cargo bikes carrying children, and heavy e-bikes will not be able to use a wheeled channel. This does not increase accessibility. They will have to continue on the 0.7 mile diversion. Excluding users, groups of these users should not be allowed in modern day standards. And although not a material planning consideration, it is surely a human one. How can this be right? Why are these users being discriminated against? Why should the opportunity of travelling actively, safely, be taken away from me? How can anyone possibly accept this design? The council and Network Rail need to collaborate to improve this design. Please get this bridge right the first time.
Repeat it, Nick. Nick Donahue, the applicant, you're on Teams.
Great, thank you. Thank you, Chair, and good evening. I'm the town planner in Network Rail's Southern region, and I'm the agent acting on behalf of Network Rail for this prior approval application. With this short time, I would like to discuss the merits of the scheme. Before you this evening is a proposal that seeks to replace 2 step footbridges with a single span bridge that will continue to provide access over the railway for the next 120 years. Whilst Part 18 of the General Permitted Development Order would allow Network Rail to renew the structures like for like, Network Rail are keen to deliver a bridge that offers some significant benefits. Firstly, the new bridge provides improved accessibility when compared to the existing arrangement by significantly reducing the number of steps. It includes the use of non-slip and tactile flooring to provide better grip, consequently reducing the risk of slips, trips and falls, and introduces a wheel channel that will improve access for cyclists. Furthermore, the proposal will increase safety through the inclusion of anti-theft and vandalism measures and better lighting. Whilst it has not been possible to deliver a fully accessible bridge at this time due to the constraints of the site, it is recognised that this is an aspiration for both the council and the local community. As a result, the bridge has been designed to allow ramps to be installed should this become feasible in the future. As you will be aware, the matters that can be considered when determining this type of prior approval are limited to siting and design. The proposal of the new bridge will ensure that the public right-of-way can continue to provide the most direct and convenient route over the railway in this location. Should it be considered that the development ought to be carried out elsewhere, this would result in a longer, more significant footpath diversion, as well as requiring additional consents, land acquisition, and likely to conflict with the built environment. Regarding design, it is considered that the modern single-span bridge will significantly be an improvement on the existing temporary scaffold bridge, and the dilapidated concrete bridge, which is approaching the end of its operational life. It should be noted that the proposal would not injure the amenity of the neighbourhood, as it would not represent a worsening of the existing arrangement. In summary, the proposal seeks to replace two bridges with the modern single-span bridge that will have improved accessibility, safety and appearance. I trust that we have addressed the matters that can be considered for this type of prior approval, and I would therefore urge the committee to support this application. Thank you.
Sarah?
Thank you very much. I'm not here to speak either for or against this application, but to provide comments for both the Planning Committee and the applicant, Network Rail, to consider. I'm well aware that this is a prior approval application and the areas of concern I have about the design are not able to be considered by the Planning Committee. However, I am pleased to see the informatives the Planning Officer has included in the report pack, and I urge the Planning Committee to include them, strengthen them further, and if possible, make them conditions. The bridge design is an improvement on what we currently have, but sadly it doesn't go far enough. I'm disappointed to see the applicant referring to Victorian legislation when we're in 2023 with little to no mention of subsequent legislation that is crucial that we adhere to, such as the Disability Discrimination Act and the Climate Change Act. That bridge isn't going to be here in 120 years' time if we don't sort climate change out. Network Rail claim, according to their website, that, and I quote, "Caring for our planet is important to our passengers and it's important to us." It also says under the title of social performance that, and I quote, "There are social benefits to everything we do and we are committed to supporting our local communities, and new footbridges over the railway can introduce safer rights of way and open up routes to more people, especially when designed for maximum accessibility." That's on their website. There is space to include ramps in the design on both sides, subject to discussions with the landowners. I've actually seen the modelling for it, so it's possible it's been a choice not to include this. Not including ramped access is discriminatory, forcing a number of residents to take longer, more dangerous routes into town, parents with prams and buggies, those in wheelchairs, those on bicycle. I appreciate that this is what happens now, but we have an opportunity to fix this problem once and for all. Simply saying that this can be done at a later date is not acceptable because we need access now, and this approach does not consider embedded carbon being the carbon cost of materials, transportation and material end of life that we're required to retrospectively do this. We need infrastructure for the 21st century, not the Victorian age. What is frustrating is that promises in the past have been made by the applicant that the bridge accessibility would be part of the design process, and a memorandum of understanding was entered into with the council to work on the solution. The council was waiting for costings to facilitate this. So for this application to have come in this manner is baffling. The applicant has ignored repeated attempts in the last few months to work on this in partnership by both council officers and the executive member. My request is that Network Rail, and I know you're listening right now, work hand in hand with the council to improve accessibility of this design as per the Memorandum of Understanding and live up to the public promises that you've made around climate responsibility and social performance, or it will be little more than greenwash. My other request is that the Planning Committee uses whatever powers it has through conditions and informatives to urge Network Rail to do the right thing. We don't need Victorian legislation dictating what happens. We need common sense.
Okay, I would like to state something personally. Network Rail has been adding lifts into most of the places where they have stair-only access in most of their stations. I don't understand why they can't do something here as well, putting in completely accessible bridge. Since Woking Town Council is willing to give them some land for this, and so is Woking Borough Council. We think this is the wrong thing to do. We think they should be doing an accessible bridge like they're doing in their own railway stations, or is it only paying customers who get the ability to be able to use things, as opposed to people who need to cross to go to work, need to cross to go and take their children with them to someplace without having this extra distance to walk. Thank you.
Thank you, Chair, and thank you to everybody who has spoken thus far this evening. I'm going to make a proposal that I hope might enable us to move forward with this rather unusual, very specific type of application.
Before we make any proposal, can I just ask a question?
Yes.
It's quite important of the officers. None of us like this. It's Victorian, but I need to understand the implications of what can we do. First of all, what can we do? And if we do it, what the implications of that are. That's really important before we start pushing around any sort of proposals, because there's no point in making proposals. I've never seen anything like this come to a planning committee before. So I'm really swimming in shark infested waters here. So I need to understand what we can actually do. We can all make a lot of noise. We can all stand around with banners telling them we don't like it, but what can we actually do?
Marcus?
Yeah, so I completely appreciate this sort of type application the council hasn't received in several years. When this came in, we had to do a lot of research to sort of figure out how other authorities have approached this. As far as we're concerned, there's three approaches that the committee could choose to do tonight. The first one is to approve with the officer's recommendation of granting prior approval. That would be subject to the informatives listed. The second option would be to add additional informatives, or in terms of what has come up today in the debates and the concerns raised with the speakers tonight, we are able to include a condition about external materials as that relates to the external appearance and design external appearance and design of the bridge. We are able to add a condition which would mean that National Network Rail, could provide further details to us before they could go ahead and proceed with what is permitted development. So we do have that option. The third option would be to refuse granting prior approval, but due to the nature of the application, and I would also refer to the example in the officer's report on page 187, this has been tried and tested before by other authorities and overturned at appeal. So that would be a big risk in my professional opinion. So I think if members are not happy to proceed with the prior approval as it is, my best recommendation would be to include an additional condition, any other informatives of anything else which may be of concern. But in my opinion, the informatives listed are very in depth. They open the door, and I think the important thing is that they make the applicant aware that other services within the council are able and willing and ready to work with them in order to get a better proposal, whether that be how they could include ramps in the future or not.
Okay, I understand that. The question, I guess, is that we're in a situation where we've just heard this will be here for 120 years, okay? And for 120 years in this borough, no disabled person will be able to cross this bridge, okay? So it's not an amenity. So immediately it fails on one of the rules, which it should be, I can't remember what it actually said, but it's something about amenity. Now, if we decided not to say anything about it and said, no, we can't support this, I'm very sorry, where does it go next?
So, as I said, if you did not want to support the recommendation and we refused to grant prior approval, then it would go to appeal, most likely.
Can we go back to my...
Could I...
Sorry to interrupt you, but I just needed to understand that.
Okay.
Lindsay.
Lindsay, would you like to give an opinion, please?
Yes, hello. Sorry. Actually, Marcus has pretty much covered everything I was about to say. I'm completely understand the difficulty members have with this application. It's a tough one to decide. It is a prior approval in that permission has already been given. It's just they need to address this condition to obtain prior approval for the local authority. It's very difficult in that it is so restricted and there's only the two points which Marcus has clearly taken you through in relation to if it could be carried out elsewhere on land, or if you could address the amenity injury that the design would have. Any other reasons are not permitted by the legislation. Unfortunately, there's nothing else to kind of refuse or condition in relation to. And as Marcus has pointed out, any refusal of this would potentially go to appeal, or any other legal challenge Network Rail felt appropriate for the circumstances. So I appreciate your concerns, but unfortunately the legislation is as it is, and we have to work within that as a planning authority.
So Alistair's bit about rubber stamping, really, this is just rubber stamping.
It's following the legislation as it's set out, and we have no options really other than to do that.
Brian?
On Councillor Kaiser's point there, the important distinction to make here, as Lindsay and Marcus have made quite clear, and as officers have made clear to members in advance of this meeting, is ordinarily this committee would not normally be debating or considering such types of applications. This is an exceptional situation where an item has been brought to planning committee which ordinarily would not be heard. Prior approval applications consist of all manner. I think there's probably 22 different sections of the GDPO covering everything from, mineral undertakings, sort of water authorities, telecom communications, and so on. Telecommunications applications for prior approvals are a prime example of the type of application which wouldn't normally be heard at planning committee because they're time sensitive. If the council does not determine them by the certain date, they have deemed consent. Going back to Lindsay's point, permission is already granted for this essential infrastructure, okay, whether it be Network Rail, waterways, telecommunications, subject to the council considering those matters for which prior approval relate. In this case, two matters: location, design. Other matters, as we have discussed here tonight, though relevant, are not contained within the legislation. Again, there's many views on that, and for those matters to be considered, the legislation would have to be changed at a national level.
Okay, can I continue? Yes. Okay, thank you. And thank you, Councillor Kaiser, for that very helpful interjection. No, very helpful, as were Marcus's and Lindsay and Brian's very clear explanations of where, what the various options are that we have available. Now, I want to make it very clear that I am absolutely in full agreement with everybody who's expressed multiple concerns and reasons to object to the current proposal, including the agent's suggestion tonight that ramps might be later retrofitted. Notwithstanding, we must not ignore the officer's very clear professional advice regarding the extremely constrained authority that our committee has in what was described a moment ago, as an exceptional type of application, and very specific, type of application that would not normally come, to a planning committee. And ultimately, our inability to legitimately use refusal and the dangers, of attempting to do that as a tool to help achieve a replacement bridge that could address the very real and significant concerns and opportunities to obtain a bridge that will be fit for purpose for the next century. There is the potential for much, much more discussion on this item. And indeed, I believe that considerable discussion has taken place in the past between Network Rail and WBC, and that there is potential for much more discussion with Network Rail and our council. And I ask the agent to help to facilitate this. But I fear that no amount of further discussion tonight is going to change the fundamental problem of our very constrained authority in this instance. And it's for this reason, to try to find a way forward, that I want to propose that we vote on the following. And these align very much with the first two options that Marcus outlined. I propose, I note that the officers include a very comprehensive list of informatives that set out concerns and how each might be addressed. I also note that additional concerns and informatives have been suggested tonight. I thank officers and those who've spoken tonight for these informatives. And I propose that the minutes state our deep concern over this project and include all of these informatives plus those additional ones that have been suggested, any that are suggested tonight. I then propose that this committee invites the executive member for planning to communicate this information as quickly and as persuasively as possible to Network Rail. And I hope that the agent will also assist in this, together with any other matters that the executive member believes are pertinent, with a view to further trying to open up meaningful dialogue and a satisfactory way forward on this matter. So that is my proposal. It's not a proposal that we vote to approve or refuse the application, but it's to take these two alternative measures.
Yeah, thank you. I feel slightly concerned that we've had such a powerful summing up before we've all had a chance to speak. Andrew, I appreciate you're in a difficult position. You've been heavily briefed by the officers, but I think it's pushing it a bit, if I'm honest. I think John raised a very key question earlier of what actually can we do about it. Other councils have tackled this. This is not a problem unique to Woking, as I'm sure you know, and as some of the officers alluded to. It's a pity that Councillor Conway is not here this evening, because I would have informed him that the Deputy Leader of York City Council led their planning committee in refusing permission for an inaccessible bridge based upon the Equalities Act. The local authority in Cleethorpes responsible for the crossing at Suggett's Lane successfully refused an application for a bridge without a ramp. Admittedly, they were backed by their local MP and ultimately by the Prime Minister, but it shows it can be done given sufficient weight. Oxford City Council also refused an application for 2 unsuitable bridges. This was overturned on appeal, but the City Council refused Network Rail land access to a 3rd bridge until a suitable solution was found for all 3. There's ample area of advice in the National Policy Statement for National Networks, and that's networks for road and rail. One of them states that all plans should reduce community severance, or the severing of communities. Network Rail control all of the crossings of the railway line from south of Woking into the town centre. If that's not a definition of community severance, I'd like to know what is. It also states that the government, and this is National Policy Statement for National Networks, so it's government legislation, the government expects applicants to identify opportunities to invest in infrastructure where the network acts as a barrier to cycling and walking by correcting historic problems, retrofitting latest solutions, and ensuring that it's easy and safe for cyclists. So there are plenty of statements available, and as Sarah Kerr mentioned, on Network Rail's own advice, and this is of page 31 of their accessible travel policy, which talks about provision for disabled passengers through inclusive design processes. I could go on, it's late in the evening, I won't. But in point of fact, we don't have to roll over on this one. I know it's the advice of our officers and indeed the legal side, but they could scarcely do otherwise. We as members do have a choice. If we don't have a choice, what are we doing here? I think what you've mentioned, Andrew, is indeed a form of deferral. It does seem to me that there's allegedly willingness, certainly on behalf of both the Town Council and the Borough Council, to make land available for the bridge that Network Rail say they'd like to install. My proposal was that we defer this application for 2 months, ask our friends in the council in the nicest possible way to get their fingers out and try and come to a deal with Network Rail, which sadly should have happened quite a while ago.
If I can just respond to the suggestion of deferral, like with other prior approval applications, this has a strict deadline, and in this case, that is the 17th of January. If we do not make a decision by that date, then they have consent to continue. So we're not able to defer this type of application.
I would ask Network Rail to please put the ramps in now, not sometime in the future, not sometime, maybe sometime in the future. We're giving it, we have the land available, and to do the right thing that they have in their own design guide to actually.
But just as a point of clarification, I think what Marcus has just said is that Andrew's proposal doesn't work anyway, because that amounts to, I don't understand the difference between that and a deferral.
As far as we're concerned, the only options that are available are to either grant or refuse the prior approval. We're not able to defer this application in any way, shape, or form. So, as far as I'm aware, so I'll let Brian jump in.
No, I think Marcus has hit the nail on the head, and that's fundamentally one of the reasons why these applications are not normally brought to planning committee, given the risk of deferral and or the limited options available to a council. They are not planning applications, and the points raised are relevant. The option of going with the agenda recommendation, and if not, refusal based on one of the reasons that we can refuse, which have been identified, those two reasons. So that would be officers' official advice. Obviously, a deferral after the 17th of January becomes defunct because it gets deemed consent.
Can we ask the agent to please pass on to Network Rail our statement of asking them to speak with Borough and speak with the town to have ramps put on and to follow their own information about how they should build bridges rather than trying to build one that isn't accessible?
Could I jump in there?
Yes.
It is officers' understanding that there are ongoing engagement between Network Rail and Wokingham Borough Council over this proposal. However, any ongoing engagement and whatever the results of that ongoing engagement will not influence the outcome of what members have in front of them under this proposal. The committee here tonight need to make a decision based on what's being presented, not hypothetically what the council could agree at a date in the future when or when other this development may commence.
John?
It's just another thing we find ourselves boxed in by. The good thing about this is that we're not looking to support officers here because they haven't negotiated something with somebody, which you have done in the other cases, which you're obliged to do to minimise the amount of enforcement. So my own view is that I would refuse it. And the reason I would refuse it would be on the basis that it doesn't meet the amenity requirements of the residents of the borough. We're here to represent the residents. We're not here to represent the rules. We're not trying to support officers in this case. So my recommendation, if somebody wants to second it, is to refuse it.
Lindsay?
Thank you. So can I just be clear, Councillor Kaiser, is your proposal therefore that it is refused on the design or external appearance of any bridge would injure the amenity of the neighbourhood? And is that is what you're kind of the route you're going down?
It is stretching it somewhat, but yes.
That is a possible reason for refusal in accordance with the order. However, Brian, I don't know if you have an opinion on how that would stand up at appeal, should it go that route?
Thank you, Lindsay. I mean, ultimately, any refusal needs to be justified. And obviously, if the committee are of the view that the design, external appearance of the bridge would injure the amenity of the local community, it would be up to the committee to specify how a replacement bridge from what compared to what is already there and being replaced is more harmful rather than harmful in a matter or a perspective that we cannot consider under those two criteria of the prior approval. So we would need more detail in order to know what officers as a council decision we were defending should it be refused and should it be appealed.
And I understand what you're saying, Trevor, and I mean you're the policeman with rules, okay? But I also like the idea of we're refusing it, and I would like to say we're refusing it on the basis that it doesn't meet the Disability Act. And I'm sure I could find a seconder for that.
Yes. Yes, you have a lot of seconders. Lindsay, could you please comment on that?
I can comment on that. That is not something that is in line with the order. I appreciate the concerns that have been raised, but it isn't something that is allowed within the parameters, and therefore it would potentially be subject to a strong legal challenge. I think the Oxford case that was referenced in the Planning Committee agenda set out a similar example to where a proposal under DDA was looked at, and I would have serious concerns if that was put forward in this case.
Well, we've heard the. I'm not trying to take your job, but we've heard the advice that we've had tonight. As members, we need to make a decision on what we want to do. I would suggest.
Are you proposing this, John?
Can I speak first? Yeah, thank you, Chair. I would very much like, to be able to support Councillor Kaiser's recommendation for refusal. But again, we've heard very clear officer advice that reference to failure to comply with disability legislation would not be well regarded if this was to come to the planning inspectorate. And it is for these reasons, that I was proposing that we do everything in our power to try to facilitate a continuation of the, albeit stalled, discussions that have been taking place between our council and Network Rail, to get those discussions back on track, to present a fairly long list of informatives, which we believe, are all achievable and which would enable us to obtain a bridge that will be fit for the future. And that, I think, is very much in line, with the officer recommendation.
Yeah, I do agree with you, but I've been around the block with these people before, right, over different things, and I can tell you that you can talk to the cows come home unless we're prepared to make some sort of definite sign, give them some sign that we are very displeased with it. We're displeased with it for lots of reasons, because we believe in protecting the vulnerable in the borough. And I really do think that tops everything tonight. That's how I feel about it.
David?
Yet again, worryingly, I find myself totally aligned with Councillor Kaiser. It's a habit I'm going to have to lose.
That makes two of us.
Yeah. Look, as I explained to some of our group at a recent meeting, if someone tells me I've no choice to vote A, there's nothing more certain that I will vote B, and that is the way I am, and that's just the fact of life. We could refuse this. We could, if Network Rail appeal it, we could well lose. To which I say, okay, we've lost the appeal, but we've made a gain in terms of making a stand and making a message. And even if it costs money, that message occasionally is worth making. As it is, I hope that if we show Network Rail we're not simply going to roll over on this because they think we have no choice, then it will at least give them some incentive to come to a reasonable discussion in the way that you so hope, Andrew, or sort out a design for this bridge that, as John said, will last us for the next 120 years, and avoid them the cost and indeed the bad publicity of taking what is actually an indefensible case to appeal. So I'd like to propose that we reject this application.
Just 1 second, Marcus wants to speak, and then we'll take a vote on. We need a seconder for John's. We have a lot of seconders.
Just before we continue, I just wanted to reaffirm, I think the best option, hearing what's been said tonight, I had talked to a highways officer today who told me that they have recently had positive discussions with Network Rail about the inclusion of ramps. So I think potentially the best option of not risking a loss and appeal and continuing dialogue between the council and Network Rail would be to impose the condition I've suggested, which would require Network Rail to supply details of external materials before they can commence the development. In the meantime, various colleagues within the council, in terms of highways and corporate ownership, they can continue those conversations as well. So I think that would sort of hand in hand continue discussions between all the relevant parties and keep the ball rolling. And hopefully, you know, the door in terms of planning, once whatever happens tonight, we're not involved in terms of how, like with any other norm application, we're not involved in how the structure is actually built. So if I've lost my train of thought there, I think the best, so they can potentially come back within the next few months with a completely new application if in the next few months conversations go up and becomes more proactive. So
but the problem we've got, and I understand what you're saying. At the moment, we're sitting in here, we have some power, okay? As soon as we walk away from this, or we try to negotiate with them, come the 17th, we have no power. Now is the time to make that point that we disagree with building a bridge that we hear is going to be 120 years on the possibility that we may be able to get people like the residents sitting in this room over that bridge. I'll be quite honest with you, I would not vote for that.
Okay, we have something that's been seconded.
I haven't had the chance to say anything, but what I want to say is if some buts and maybes, sorry, which is what I'm hearing here, maybe we might be able to, if they, it's not really enough, and I'm conscious, my own conscience is I couldn't sit here and vote for something knowing that.
Yeah, I think Andrew's point is he's going to get the exec member for planning to speak to Network Rail. Well, should have done that already. And it hasn't worked. Has it gone up to Susan? Has she spoke to them? Is it important? Has it been on her agenda? What's happened? It's obvious that it hasn't happened. I absolutely understand the predicament we're in, but John's right. If we don't use the power amongst this committee this evening, no. But what I can't understand, listening to Nick earlier, they talk about ramps. Well, there's no better time to put in ramps. The cost of construction is when you're doing the job. So what I can't understand is where the disconnect has come, and it won't be with the planners, where the disconnect has come between the discussions between WBC and Network Rail. There's obviously something there stopping. I mean, I know what you say, Marcus, about you spoke to a highways guy this afternoon, but quite frankly, speaking to a highways guy, this should have come from Network Rail tonight. He should have said it.
Okay, what is the exact wording for the proposal that's before us? Either David's or John's, whoever.
Right, my proposal was that we refuse this application on the basis it denies human rights to the most disabled people in the borough and under the Equality Act.
Okay, first of all, David, what did you want to say? And then we'll ask Lindsay. Then we'd like an opinion from Lindsay.
Well, I'll do a cut line. What Marcus said earlier was right. Bin this proposal and come, if what we've heard is true, come back in a couple of months with a better one that includes the ramps. Job done. But I simply support what John has said. I'm happy to second that motion.
Opinion on the wording.
Lindsay, an opinion on the wording, please. Lindsay?
Hello, sorry, it's just taking me a moment to come back on. I don't think that wording will be appropriate. I think, as I mentioned earlier, there are two strict criteria for which something could be refused, and you did allude to the injury to the amenity. I think it would be not necessarily a successful but a safer bet to refuse on that basis rather than on the disability, which isn't allowed under the terms or isn't permitted under the terms of prior approval applications. So, and with regards to the deferral, I think Marcus has made that quite clear. The decision for this has to be made by I think it was the 17th of January, otherwise prior approval is automatically given. So a deferral just would not work.
It's a shame that doing the right thing is not an acceptable reason.
We just say then we don't believe that it delivers the right level of amenity for the residents of the borough.
There is something before the planning committee now. Al,
to say, I mean, I think this ought to be tested before the planning inspector then, I mean, I think we ought to, put our view here and we can find out whether it's acceptable or not.
Okay.
The proposed new bridge, in our opinion, does not comply with the requirements of the Equality Act 2010, which disadvantage in comparison with persons who are not disabled. There's your, that's what you could put.
Okay, Andrew?
Yeah, my understanding of Lindsay's advice was, though, that we should not go with that as the reason, but that we should use wording relating to amenity, design and amenity. And I think, Callum, do you have some wording based on what Lindsay recommended?
Yes. So I believe the original wording Lindsay gave was to refuse on as the design would impact on the amenity of the neighbourhood. I think that was Lindsay's original wording.
That's fine enough as far as I'm concerned. I just want to refuse it.
So can I just...
So do most of the rest of us also.
Just for the tape, John. So you're happy to refuse it on the basis that the design the design impacts on the amenity of the neighbourhood. Just simple as that.
Yes, I'd like to propose that as a motion. Would somebody like to second that?
Second.
Lindsay, was that wording correct?
David is seconded.
I'm just looking up the wording. Sorry, bear with me. So it would be that the design and external appearance of the bridge would injure the amenity of the neighbourhood.
And the access for all the residents.
I've made my points on the access and the Disability Act. I'm just concerned that if you went down that route, which is outside what the order allows, you are potentially looking at an application of costs in any appeal situation or further challenge.
Okay, thank you, Lindsay, and thank you, councillors. At this juncture, I might just add some additional information which may prove useful or not. With prior approval applications, the ability exists through the regulations to seek an extension of time to the initial determination date, in this case, the 17th of January. Now, ordinarily, extensions of time must be agreed in writing. There is the ability for the committee, if they so felt the need, to extend the time beyond the 17th. The agent for the application is at committee, is on the call, and so a verbal request could be agreed and then followed up if members felt that additional time was required to either consider the points, the reasons for refusal. It would obviously need to come back to a planning committee for a decision, but likewise matters pertaining to whether communication from the executive member to Network Rail would proceed, or whether a condition or other, as Marcus suggested, would be more beneficial. So I suppose it's worth just making you aware that there is an article in the regulations that allows the council in any case to seek extensions of time. Ordinarily, we wouldn't be in this situation. As I say, the committee does not get presented with prior approval applications. Councils do and often seek extensions of time on other prior approvals. But again, this is officer agent when there are matters to be resolved. So I just thought I would bring members' attention to that before a decision was made.
Can we ask the agent whether they are willing to extend the deadline?
Hiya. Do you know how long you'd be looking to extend the deadline? I guess that's the key bit.
Just a second, we're getting the date right now. It would be Friday, the 10th of February, which is 2 days after the next committee. In the meantime, we'd like Network Rail to speak with Woking Borough Council, including the executive member for highways, and to do this.
Okay. Yeah, I think that's prudent.
I think you would need to agree that the item be deferred. So an extension of time agreed to allow the item to be deferred, subject to the information or the actions you wish to be undertaken.
Okay, do we agree that the item to be deferred for this?
I'd be happy with that because I think the deferral's the better course of action and it gives us the opportunity, and we are still in a position of power because we haven't approved it.
And I think Network Rail would also have some time to actually discuss it with the borough. Will you agree the extension of time?
Sorry. Yeah, I'd agree to the extension of time.
Yes.
Yeah.
Okay. All right. Okay. Vote on it. Proposed by John. Extension of time. Seconded by David.
I'm proposing in agreement with the agent that we go for a deferral until what was it? The 10th of February.
Okay.
All those in favour?
Yeah. All those in favour? It's unanimous. Thank you.
Excuse me, because I've staked.
The learning there is there's always an alternative way if you look hard enough.
We don't have any more, do we? By the way, the meeting, don't we have something else we're discussing? We have 2 more items, just wait till John comes. Sorry. You see why we need a 10-minute break? Nothing else. Planning committee seems. Okay, we're now going to the next application. Application number 223021, land west of Twin Oaks, Longwater Lane. The case officer is Heather.
Sorry, it's Helen.
Pardon me, Helen.
That's okay. Thank you, Chair. So this application 223021 is for the change of use of an existing equestrian site to a mixed use, which comprises an equestrian strike and one caravan pitch and day room for a gypsy traveller use. So this is the site outlined in red. To one side there is an existing gypsy pitch, and the other side there is an agricultural mobile home. At the front of the site, this L-shaped building here is an existing stable block. So the site is located within the countryside. This plan shows the settlement boundary in yellow and the countryside in green. As noted in paragraph 4.7 of the officer's report, previously the site has been determined as so close to the settlement boundary by an inspector that it cannot be argued to be unsustainable or isolated, and it's considered as an edge of settlement site. Therefore, can be supported by our policy TBO 10, which allows new sites for gypsy and travellers on the edge of settlements, providing that they do not disproportionately affect the settlement itself. This is the site plan. The existing stable block is here in the L shape. The day room is the centre of one of the converted stable, and then this is the pitch for the mobile home. Again, this is the floor plan of the stable block, showing that these parts are remaining as stable and this part will be converted to a day room. So this is the site as existing. As you can see, it's the front portion of the site. The application is submitted retrospectively, so the caravans are already on site and the day room has been converted here. So this is the rear of the site, which is the equestrian paddock area, and that part of the site is to remain unchanged. So the application for the mixed use retaining the equestrian use with the addition of a gypsy and traveller pitch is recommended for approval subject to the conditions set out in the officer's report and the completion of a section 106 legal agreement to mitigate against the impacts on the SPA. So the applicant has appointed a solicitor to deal with the section 106 and in principle has agreed to sign this, but no further work has been done until after the date of this committee has made their decision. The site does contribute to the 5-year housing supply for gypsy traveller pitches. And it is acknowledged that the site is technically outside the settlement boundary and within the countryside, but given there is no detrimental impact to the area and the context of the site is considered acceptable. I also would like to note that I've received confirmation on the 9th of January that the commercial unit that had been stored on the site has now been removed, and that was the subject of a number of residents' comments. So this application is recommended for approval subject to the conditions and the 106 as set out in the report.
We're going to ask for an extension of time to deal with this, to deal with this meeting.
Until 11 o'clock.
Till 11 o'clock. Okay.
So Councillor Roger Marshall,
Okay. Councillor Roger Marshall again.
Thank you, Chair. Again, I'm appearing, speaking on behalf of Finchams Parish Council Planning Committee. We have objected to this on a number of grounds, but I'm only going to concentrate really on one this evening, and that is that it's not in accordance with the evolving neighbourhood development plan. I'm in a little bit of a quandary because
I've received conflicting information this evening about the position of the neighbourhood development plan, how it's considered by Wokingham Borough Council as to whether it is of no consequence or whether it is as specified yesterday in the document I received. The committee report refers to the Finch neighbourhood plan at various points in the report. The plan has been applied moderate weight to the policies therein on the basis that it is at examination stage. Now, that comment actually related to the housing in Johnson Drive, potential housing Johnson Drive, but the status of the plan should clearly be common to all applications we're considering at the moment. So I'm going to work on the basis that what was issued yesterday is the correct assumption and that it is being offered moderate weight. Unfortunately, in the report that the officers produced, she says, given that the stage of preparation, the FNDP has limited weight in the decision-making process of at this stage. And in fact, she doesn't refer to it at all subsequently in her paper. And one gets the impression that it's actually been disregarded, particularly when you come to the section 18 in the report, which says planning balance, and 18.3, which really is summing up the overall opinion. The fact that the council could clearly demonstrate a 5-year supply of gypsy and travel pitches weighs against the proposal when it is located within the countryside, and this clearly is located within the countryside. However, additional supply is supported where it provides a safeguard for future supply, and particularly in the case where it is established within previous developed land without detriment to the character of the site or amenity where the family connections can be demonstrated. On this basis, the benefit of the proposed weight in favour of the application is recommended for the approval. Now, in that section and in the associated paragraphs,
can you please sum up?
Okay, in that paragraph and in the associated paragraphs, there is actually no mention to the neighbourhood development plan, for which we have a clear situation from the council that this should have moderate weight.
Okay,
and I believe this approach is invalid on that basis.
And Mr. Cundy? Roland Cundy? Okay.
I can start the clock. I speak on behalf of the residents in Longwater Lane and Caulfield Close. The site, like the officer said, is unsustainable. WPC core policies CP6, CP9 and CP11 set out the core strategy with regards to access to local retail, leisure, medical facilities and services and the promotion of sustainable transport. The local shop, post office and petrol station in the village has been closed for 2 years. There are no other facilities. CP1 Clause 11 says that the proposals must demonstrate how they support opportunities for reducing the need to travel by private car. This application fails to meet these criteria. Whilst it is adjacent to a settlement, the settlement itself contains no retail or medical services. Proximity to other houses does not define sustainable development, as per the decision noticed by the inspector in an appeal relating to Johnson Drive, page 53, paragraph 10. More sustainable G&T accommodation can be found in the extra provision of pitches at land to the rear of 166 9 Mile Ride, which is why that site is supported for expansion. The local residents' concerns, this is a form of creeping development. A previous refusal considered this would be harmful to the rural character and appearance of the area. WBC then allowed a substantial stable building yard with close board fencing and then claimed that the area now has the built form that cannot be further harmed. The site is accessed by a public footpath that leads down to a popular nature area on the south side of Longwater Road. It is crossed on both sides by another right-of-way. This will have potential conflict with many regular walkers, dog owners, and potentially cause further damage to the muddy, uneven surface by vehicle movements. The footpath has no footway, so the on-foot users step aside on this 3-metre access while vehicles pass. Due to level of heavy traffic, various improvements to the footpath surface have raised the level of this to such an extent that a lake now forms at the bottom end of Longwater Lane, which causes foot users to trespass on neighbours' property to get access to a footpath. In your agenda pack on page 213, paragraph 7.5, WBC states that the lane at this point is much more rural in appearance, although this has been altered by the introduction of a gypsy pitch at Twin Oaks. Clearly, the introduction of yet another GT site to the west of Twin Oaks will further spoil the countryside and reduce the rural appearance of that area. We strongly object to this proposal. Thank you.
Emily Temple, agent.
Thank you, Chair, and good evening, councillors. As presented, this application seeks a change of use from an existing equestrian use to a mixed-use development for a caravan pitch and equestrian. The caravan pitch is needed by the applicant and his family who are local to the area, and they were evicted from a site due to overcrowding. We welcome the officer's thorough report and recommendation for approval and would like to take this opportunity to address some of the comments that have been received. The application site comprises previously developed land and it's located between 2 neighbouring sites that feature caravan uses. As such, the development does not encroach further into the countryside than the existing envelope formed by these and the stable block on the site. The location has been identified in local appeal decisions as being suitably sustainable in terms of its proximity to facilities and amenities. Some comments were made regarding highways and pedestrian safety, and these have been raised in the officer's report, a previous inspector's decision, and the council's highways officer, who have all found no objection to the proposal's impact on highway and pedestrian safety or traffic generation. The proposal is for a single caravan pitch for 1 family. The applicant has also instructed a solicitor to secure the Section 106 agreement to address the Thames Basin Heath SPA policy to provide the SANG mitigation for this development. And the site is subject to a management plan for the grazing area to the rear. And so there would be no adverse ecological effect from this proposal. I note the list of conditions in the officer's report, which we will adhere to address all of the other matters that have been raised by the council. The approval of this application would provide a settled base for the applicant's family and prevent making them homeless and vulnerable. The family are already local to the area, and the location of the application site allows for their children to remain at their current school and to keep access to their registered Finch Hampstead GP. In light of the council's January call for more gypsy sites to be submitted, this proposal would also provide a pitch that would contribute to the council's long-term supply. I note the comments on the Finch Hampstead neighbourhood plan. The neighbourhood plan policy only refers to the expansion of existing sites. It is silent on the provision of new sites. I trust that my comments are reassuring to members and conclude by thanking the officer again for their professional assessment and our confirmation of adherence to the conditions that are laid out before you. And I respectfully ask that members support the officer's recommendation this evening. Thank you.
Members, David.
Chair, thank you. As I explained earlier, I called this in at the request of the parish council and of local residents. And I have to say, my first impression was to those folks, are you sure? This is in many ways one more site down a lane where there are other, as one of the other speakers said, other caravans and mobile homes present. I can fully understand the reasons why WBC officers are seeking to approve this. And I think we all know that yet again, this is another retrospective application. This is another request for, I won't use the phrase quiet life, but actually an expeditious and pragmatic solution to a problem which might be better not dealt with. And that's common sense, and I have a lot of sympathy with common sense. But there are other issues where I think the officers have not helped themselves. We return yet again to the vexed question of what weight the Finch Hampstead neighbourhood plan carries. Despite the fact that officers have contradicted themselves in the papers of this meeting, I note the comment that Brian alluded to from the strategic planning team, who I know well. I regret to say I think they're incorrect. I have a paper here provided by our neighbours in Hart District Council only 2 years ago, which sets out weight of emerging neighbourhood plans. It says quite clearly, when it's past the public consultation stage, which the Finch Hampshire plan has, it carries increasing weight. When it's going through examination, it carries considerable weight. I won't bother meeting further with those details, but I'm sure Finch Hampshire Parish Council will be seeking separate professional advice on that, and I will be discussing that with our own strategic planning team. The papers that we've got for this site also make reference to need and personal circumstance, to which I'm highly sympathetic, particularly when you have a young family who are settled at school and from the area. But again, the policies or the statements that the officers make are contradictory. The PPTS sets out guidance to ensure fair and equal treatment for gypsies and travellers, and Part H and Parts A and B refer to local provision. But WBC itself states that it can more than meet local need already, and has been mentioned, alternative and more sustainable locations have been made available at 1669 Mile Ride and recently by appeal at 23A 9 Mile Ride, all of which are far closer to the retail and other services, including the GP surgery, than this location is. In para 4.24 on page 210 of our meeting pack, the statement is made that the pitch is to meet the specific needs of an existing family on the site. WBC have made no comment on the applications to any special personal need or circumstance, but I'm sure it exists. But if it does exist, then this could be covered by means of a personal permission condition on the site. And had a personal permission condition been applied to this application, I would have seen little reason to oppose it. But however, on page 211, para 4.38 of the same pack, WBC now state the objective here is not to meet need and personal circumstances, but simply to increase the number of pitches in the borough regardless of current need. There's also a basic conflict with core strategy. This site was promoted to the council as being available for gypsy and traveller provision in 2020, but the revised growth strategy consultation did not propose the allocation of the site, with other sites preferred. WBC officers are now stating on page 212 of this pack that the local plan update currently has limited weight. But I was advised only yesterday by a member of the strategic planning team that the RGS is still the current consulted plan. So both of those statements can't be true. And in any case, the existing plan runs until 2026 and the policies still apply when gypsy and traveller site provision numbers still meet the target. The planning officer concern admits on page 211 that the objective is to increase the number of pitches in the borough, regardless of current need or emerging strategy. So I ask which part of the planning team is actually making strategy and policy? The reduction of the LPU and core strategy is already fraught with difficulty in trying to balance the wishes of residents against national policy for development. And it's not helped by one part of the WBC planning team trying to work against the strategic direction of their colleagues. As I said at the start, undeniably there are some very sound and pragmatic reasons for approving this application. And on a less contested site, I would support doing so. However, we ask our residents to accept that planning is not decided upon whim or convenience, but according to policy and a rules-based system. Approving this application requires us to ignore many policies of the Borough Council, the policies of the Emerging Neighbourhood Plan, the concerns expressed by the Parish Council, and quite clearly the views of local residents. The pragmatic convenience of avoiding enforcement is not, in my opinion, sufficient reason to undermine the rules-based system to which we ask our residents to subscribe.
Anyone else? Al?
Well, I mean, it seems a modest enough development to me. I mean, helping a family down by parking a caravan. My neighbour's got a enormous caravan parked on their drive. You know, it's not. I mean, I can't really see the problem with this. I mean, I think this evening, you know, we've approved much more intrusive developments in early with these, you know, than this particular development. You know, it seems perfectly reasonable to me. So I will support it.
Andrew?
I was minded to approve this application, but I've been very, very much persuaded by the very cogent arguments presented by Councillor Cornish that have also alluded to quite a number of issues that perhaps I didn't, that I wasn't as fully aware of, as I might have been, before this meeting. With the caveat that I do have sympathy, with the view taken by Councillor Neil, and indeed with what the family, who've lodged this application, are seeking to achieve. But I think, on reflection and very careful reflection, that the issues at stake here, are multiple and of considerable consequence. And I think there may well be other people who wish to contribute to the discussion that might further influence my decision. But at the moment, I'm veering much more, towards a recommendation for refusal.
At the start, when the officer Helen presented it, she said that this wouldn't have a detrimental effect to the local environment. There are issues to this site. The access road is a mud track. It is unsustainable. The only access to this property, this area, is by vehicular access. There are already issues with quite considerable flooding up the lane. So I can't agree that this wouldn't have a detrimental effect to the local environment. It is within the countryside, so again, we're another one that we're steering away from policy, and it's outside the settlement boundary. So they are concerns that I have about this application.
John?
Yes, thank you. I mean, this is another application where officers have negotiated because there are breaches of enforcement breaches that need enforcing. The trouble I've got with this, to be quite candid with you, is that if the officers negotiate with residents with regards to solving a problem, I'm not quite sure where we are in all this, because we employ officers to be professionals. They make a judgment. They have to, because of the way the legislation works around enforcement, they have to try and mitigate if there's applicant and encourage the applicants to submit an application. And I'm just a bit at odds with it. I mean, if the officers are saying, well, as far as we're concerned, this is the best way to deal with this matter, I'm not quite sure whether I feel strongly about voting against the officers, to be honest with you, because they're coming to us and saying, this is the best you're going to get, guys.
Helen?
Can I just add to that, Councillor Kaiser? I don't believe this came from an enforcement investigation. So the application was lodged and there was no enforcement case. That was the applicant who lodged the application of their own free will. But obviously they became in a situation where they were homeless, and during the course of the application, they moved onto the site due to their personal circumstances where they didn't have anywhere else to go. So it was
there would have been enforcement at some point.
There has been historic enforcement on, there have been enforcement cases on this site, but not relation to a gypsy pitch. There has been sort of fly tipping type issues there, but nothing to do with this particular application.
Okay, thank you for clarifying that.
Wayne?
We hear so often the issues around our sites. We feel that we're very comfortable with our supply, but when you go and test our supply, it's not as good as what you think, because they're not individual sites. They are sites owned by certain individuals that will allow certain people onto those sites and won't allow certain others. So when you read the notes around what our provision is, No wonder we've gone out for a request for more sites. I think it was this week. So I don't know how the applicants got into the situation they've got, but you see it so often around our borough because the majority of our sites are run by a few people. And then there leaves us a problem around individuals that will not have a home. And I'm not going to go into the neighbourhood plan because I think, you know, Councillor Cornish has done that, but we're in a predicament here. And I come back to the word harm. That's what we've got to look at, harm.
David, and then we're going to go to a vote.
Yeah, I listened, as I said at the start, with a very open mind on this, because I think the arguments are powerful both ways around. We've talked a lot about the rights of the applicant. Clearly, the local community and local residents also have rights that need to be upheld. On balance, and it is a fine decision, I would still oppose this, but I would ask that if the committee is minded to vote in favour of approving it, that we at least attach the personal provision condition to the application. Because if we do not, it does then serve to undermine the future of the neighbourhood plan. The Finchampton neighbourhood plan, trying to be generous in its gypsy and traveller provision, expressly permits the expansion of permitted sites. If this becomes a single site, then it's got assumptions for expansion in the future, which is not the purpose that we try to apply.
Ellen, would you like to confirm?
So thank you, Chair. So just on that point, the application has been assessed without, assessed as acceptable without a personal permission, personal condition on the application. However, to put one on would therefore not meet the tests of the PPG, the 6 tests for reasonableness for planning conditions.
Just explain that a little bit.
Could you explain that a little bit more, please?
So the applicant did put forward some personal circumstances which are noted in the officer's report. So they do meet the criteria of being gypsy and traveller, and they do meet that definition, as well as they have their children in local schools and they are registered at the local GP surgery. So they do have a need to be in that location. So that has been put forward in the officer's report as something that was noted. However, notwithstanding that information, that the site, there was no harm to the site as a gypsy and traveller pitch for any persons who met that criteria. It didn't need to be specific to those persons, and as the site in itself was considered acceptable and there was no harm, there was no need to make an exception by putting that personal condition on it and making it effectively a sort of temporary permission, which is alluded to in the supplementary report as how the tests work and the reasonableness of that condition.
Okay, Andrew?
I can recall applications for similar sorts of applications where the approval has been attached to a very specific family, and my understanding is would lapse, should, if and when that family vacates the site. I feel, given some of the things which have been said tonight and concerns which have been raised, that despite the assessment that this site could be suitable for any family, such family, I think that given the concerns that have been raised tonight, if there's any way that it would be possible to attach that personal, if that's the correct statement or the correct term, condition, then I would support that.
Is there a proposal to attach the David?
Chair, I'd like to propose that we approve this application subject to the attachment of the personal permission condition.
Is there a second? All those in favor? Of this particular thing? Now we'll go to actually approving the application or not. Okay. All those in favor of approving the application with the change?
Couldn't you just ask the agent if they were happy with that, Helen?
Yes, of course. Okay, there you
Okay.
go. I did get that indication.
So
Can we just include the section 106 in that vote as well? Thank you.
okay. It's approved. And the very last one of the evening is Temple Coombe, and we have exactly 17 minutes to do it. Simon is the officer. Simon?
Thank you, Chair. The application relates to a replacement dwelling at Temple Coombe, which forms part of Park Place, Grade 2 star listed registered park and garden. That's the wider view of the site. Closer in view of the site, you'll note to the due west of it, there's also Grade 2 listed Druids Temple. This is a side-on view of the site with the Thames River on this, in the River Thames, sorry, in the background. It is also within the Greenbelt. It is within the countryside. There's local wildlife site. There's woodland. There's protected species of species and habitat of critical importance. The proposal includes a rear carport in addition to the replacement dwelling. There's no objections from the parish council or from any residents, though there is an objection from the Gardens Trust and from the council's landscape officer. There's no objection from the ecology officer or from Historic England. So I'll just take you through the plans briefly. This is the existing site area. This is the design of the dwelling from the front and rear of the building and from the sides. The existing dwelling is shown on the screen at the moment. That's the setting out towards the Druids Temple. There's the existing pool house that's looking back towards the existing dwelling near the tennis court, and that's the drive up to the site. This is the proposed location of the new driveway, and that is the Grade 2 listed Druids Temple adjacent to the site. The four primary issues are that it's inappropriate, whether it's inappropriate development in the Greenbelt, the ecological harm, the setting of the registered park garden, and the design matters. Just dealing briefly with the Greenbelt, it is in the officer report concluded that there is a material increase in height, but overall there's not a materially larger impact upon the openness of the building and of the building it replaces. So it is not inappropriate development in the Greenbelt. Ecology issues are addressed by condition or within a section 106, which will be incorporated as part of a wider intention to mimic or to address issues that are part of the registered park and garden. The objection for the landscape officer is not concurred with in the sense that the proposal does achieve a satisfactory outcome for the site. The design issues are acceptable. There's no objection on design grounds from the Conservation Officer or from Historic England. So the application is recommended for approval subject to a conservation management strategy for the site. Members' update does include a condition for excavation, which I'll put up on the screen for you now. Is raised by a member of the committee in relation to what is occurring to the excavation for the site. It is envisaged that most of the excavation will be reused on the site for accommodating the relocated driveway, but that condition is proposed as part of the additional supplementary agenda. There's also advice from the Gardens Trust reiterating their objection. Thank you.
Okay, the agent, Alan.
Thank you, Chairman, members of the committee, for this opportunity of addressing you this evening. I realise that I'm running against the clock, so if I speak too fast, you'll have to bear with me. This proposal has been subject to a fairly lengthy period of pre-application consultation, which commenced in March 2021. This has involved 2 rounds of discussions with your planning, highways, ecology, landscape and tree officers, Berkshire Gardens, English Heritage and Berks Archaeology. The proposals have been amended as a result in response to the feedback provided. The responsiveness to feedback received has continued during the current application process, with your office's suggested design amendments now reflected in elevation changes and the deletion of the bin store pool house from the current proposals. The fact that the application is supported by English Heritage and now recommended for approval is, in my view, testament to these extensive pre-application consultations and interactive engagement processes. Templecombe Estate is located in the Greenbelt and contains the listed Druids Temple, a designated wildlife site, and forms part of the wider Park Place registered park and garden. These have set the parameters for the proposal, and through the various technical assessments that we've undertaken, landscape and visual impact, heritage, archaeology, trees, etc., we have sought to demonstrate that these considerations have been addressed. The sensitivities associated with these designations have therefore featured highly in our technical and design work and will continue to do so as we progress the Woodland Management Plan, the Conservation Management Strategy and the Construction Environmental Management Plan, with the first of these 2 documents applicable to the whole of the Templecombe Estate and not just the Red Line. Our commitment to these plans and strategies is evident from the drafting of the Woodland Plan, which has been sent to your officers in draft, and also the synopsis of the Conservation Strategy, which has also been sent to your officers and will feature in the Section 106 agreement. We are committed to maintain the collaborative approach that we have established at the pre-application stage to work with your officers to ensure that Conservation Strategy, Woodland Plan apply to the whole of the estate and achieve our collective objectives. In summary, this is, in my view, a technically sound and policy compliant proposal. It is for a new dwelling to replace an existing dwelling in the same location and which is not materially larger than the dwelling and pool house to be replaced. It has the support of your planning officers, and I hope that in turn you will be able to support the application with a positive resolution. Thank you. And since I am here in person, if I can assist with any clarifications or further information, I'm happy to do so. Thank you.
Okay. Members? Anybody wish to speak?
Anyone wishing to make a proposal?
Anyone would like to make a proposal? David?
I propose we approve the application.